May,
May
may,
I-
please-
Yes, Mr. Agarwal.
may I have liberty to your lordship mentioning 3 matters, my lord, which are running in the hearing list, my lord. Your lordship directed me to mention it after it appears in the list. It appears in the list so that the date may be fixed, my lord. This is item number 214. The petitioner is suffering cancellation of the license, my lord. 214,
214.
154 and 155.
214,
154, 155. Well, in
154 and
1415 and 1455, my lord. Here I am appearing for the prior dismount. Let me continue to confess your lordship, my lord. Here I am not very much suffering, but in 214 I am suffering, my lord.
So you want to list the 214.
14 any day, my lord, at 2 p.m. or 10:30, whatever your lordship, my lord.
You are for the petition.
My lord. There is already
All
stay.
pleadings complete.
All pleading complete. Stay is there, my lord, but still suspension is continuing.
Stay is there.
Stay of fine is there, but
Stay
suspension.
of fine is there.
But suspension is continuing.
Suspension is there. So before vacation.
Any day, my lord, before vacation, because already.
Before vacation is
Well-
not possible, I think.
Anyone, let kindly have a date so that before
Okay,
vacation I may take a chance.
Okay, before vacation you can take a chance. একুশে দেখুন 21st কিছু আছে 21st 2 p.m.
My lord.
Only one matter.
Okay.
214.
214. my lord.
Item number 214.
এটা দিয়েছি।
On mentioning this matter, item number 214. Be
Item number 59.
listed on
Lord, I am
1st of
mentioning
May 2025. 21st of May 2025 at 2 p.m.
Lord, I am mentioning item number 59, my lord. Kindly take it up, my lord, day after tomorrow, my lord. 59. I'm for
Item
the
number
response.
59.
59, my lord.
Mr. Mukhopadhyay, item number 59.
59, my lord.
Okay. Who is for the petitioner? Have
My
you
lord, I am
served?
for, there is that matter I have to Shipur, my lord. I am for the, my lord, alleged contempt, lord. I've got personal difficulty, my lord. Kindly take it up day after tomorrow, my lord.
Who is for the petitioner here? Have you served?
No, my lord, I shall inform.
Okay.
I know her.
Let it be called. Let I call it.
But
Okay.
I will be not,
Next.
I will
But
be
I have
not,
to your lordship, one,
Yes, Mr. Mukhopadhyay,
I will be not here. I'll go
I
to
shall not
doctor,
take
my
up
lord.
your matter today.
one file is here, my lord, but since your lordship was not sitting, it was not listed, my lord. Let it appear mentioned matter, my lord. This deeply applied.
No, this is that matter which, upon mentioning your lordship, had fixed on 17th of April. That modification during vacation, your lordship had passed in order.
Okay.
My lord, kindly take it.
Listed.
Or may I permit to, my lord, petitioner praised for cancellation of the license of the private respondent. My lord, your lordship heard the matter on 21st January 2025. Thereafter, your lordship directed to the state to file report within 4 weeks and reply, if any, within 2 weeks, my lord.
No report.
No report, my lord. But I have served that all respondents.
To be mentioned tomorrow.
I have permit to mention, my lord, one motion, my lord, for inclusion.
Group 8,
Land matter, my lord.
group 1.
This was appearing in the erstwhile bench, my lord. but
Okay.
it appeared
So
in-
up to 2022, I have determination. Okay.
May I have your lordship's kind leave to mention an application under Group 8, my lord. This application is about, my lord, the evaluation process was under challenge. My lord, we had taken this point that 2023 evaluation notification was not adhered to. In place of that, 2021 notification has been adhered to. I am covered by your lordship's own decision in this regard, my lord. I was praying for listing of this application, my lord.
Under heading application.
Grateful, my lord.
Your Lordship, WPA 8183 of 2024, Your Lordship was pleased to reserve the judgment on 22nd of April 2025. This is the matter where the allegation has been brought against the dead person. Your Lordship was pleased to direct
Yes.
to hand over
Written notes of
written notes of
Yeah,
This is the order, your lordship.
I know.
Lordship, I am mentioning stay application for ad interim injunction order.
Ad interim injunction order in respect of what?
Stay application.
Stay
Land.
application in connection with
Land.
group 1
Yes. ma'am.
within 2022. What is the number of the matter?
SA 38 of 2015.
SAT.
Yes. ma'am.
SA, I don't have the determination of SAT.
SA.
SA, I don't have the determination of second appeal. Now I don't have determination.
Lordship, may I be permitted to mention one writ petition? Your Lordship was pleased to dispose of the matter on 22nd April, Your Lordship. However, inadvertently, the date of the order has been recorded as 22nd May.
For correction, tomorrow.
There was a direction for notice, my lord. They did not serve the notice since 15th January, my lord. We
Have to serve.
have served the notice.
What do you want?
Let it be in the list, my lord. Let it appear, my lord, so that the state can.
Day after tomorrow to be mentioned.
Deep
Group
down.
8 matters. No, group 1 matters.
Group 1 matter.
Group 1 matters.
Plan matter. Group 1.
Plan
Well,
matter. Thursday. Thursday to be mentioned. Thursday to be mentioned.
Another matter, my lord, is a legal matter. The affidavits and the exceptions all are complete, my lord. Since 2013, my lord, the old man is waiting. He is aged about 87 years.
Group
my lord.
1 matter
Group 1 matter, my lord.
for listing.
Lordship's kind leave to
Keep
mention,
it.
my lord, one matter relating to the Jalpaiguri circuit bench matter.
Yes.
Now, my lord, this is a MSCC matter. My lord was pleased to pass an order. My lord, but in that order, the apportionment of the claim amount has not been given. If your lordship can kindly
Apportionment of.
the award and the interest, my lord.
So order is there. So what you want for correction?
Yes, my lord.
Jalpaiguri matter for correction. Why?
My lord,
There are bench. There are
asked
benches.
by your lordship, my lord.
Maybe passed by me, but there are some benches. Why
Simply-
mentioning before this court?
Simply, my lord, subject to correction, my lord.
Have you mentioned before this court?
No, what, my lord, the practice has been, my lord, and
Okay, give it to me.
the honorable judge, if he is there, my lord, even in the principal.
I
bench-
understand, but the principal bench, that can be done. In the circuit bench, there is difficulty.
I understand, my lord. Yes, they will
The
find it
record has to be called for, everything has to be done. This is the
But,
difficulty.
possibly, my lord, other honorable.
Okay,
judge will not
okay,
take
okay.
it.
Your Lordship may be permitted to mention one matter for upgradation. It is currently listed in monthly list item number 121. Your Lordship, the petitioner by way of this writ petition has challenged the selection procedure for MR distributorship. Despite having required documentation, the petitioner have not been considered, but another person has been considered who have suppressed some crucial facts, which has stand him liable to get rejected. Now, Your Lordship, the urgency is that it has come to attention that the Department of Food and Supplies is soon going to deliver the equipments to the said licensee. Your Lordship, if the equipments for the operating MR dealership is delivered to the said licensee, our matter becomes infructuous.
Why?
Your Lordship, it will be delivered to the licensee and he will start
You
running.
have challenged the license.
Your Lordship, I have challenged the selection procedure for distributing the MR
If the
distributor.
selection procedure good, everything would be good.
Yes, Your
If the
Lordship.
base is good, so where is the urgency? License has already been given. I can
Yes, Your
understand
Lordship.
your submission. If the license was not given there, license has already been given. Let them proceed. If if it appears that the procedure is entirely bad in law, so entire procedure, including the license, should be cancelled.
Your Lordship, we have invested a lot of money in maintaining our godown as per the procedure, as per the terms given.
Yes, your
by the-
godown is there. Your
Yes, Your
godown
Lordship,
is
we
not
have the
evaporated.
essential things.
So let them let it matter. What is the matter? Oh, this is come under the
Item number-
motion matter. It will take up. It will be taken up this week. It will be taken up this week also.
Okay, Your
Okay, not necessary to upgrade.
May I be permitted to mention one matter?
What?
Application, inclusion for application for appropriate order, land matter, group 1, 2018 matter.
2018 matter. Thursday, under heading application.
Your Lordship's kindly leave, my lord, to mention, my lord, two contempt matters, my lord, which were supposed to appear, my lord, in the list, but have not appeared, my lord.
You have filed 2 contempt matter. So what you want?
For inclusion in the list, my lord.
Call the list.
Before my last,
I have already concluded my submission, my lord.
only one judgment, my lord, one recent Supreme Court judgment, my lord, the view that has been laid down Same as the law has been laid down in the other matters, my lord. Judgment reported in 2024, volume 10 Supreme Court cases. 2024, volume 10 Supreme Court cases 273. If your lordship comes to the head note, which deals with scope of judicial intervention in government contracts. A little later part of that by way of judicial review. Has your lordship got it?
Yes.
By way of judicial review, the court cannot examine the details of the terms of the contract which have been entered into by the public body or the state. Courts have inherent limitations on the scope. Kindly marks the word. Courts have inherent limitations on the scope of any inquiry, but at the same time, the court can certainly examine whether the decision-making process was reasonable, rational, not arbitrary, and violative of Article 14 of the Constitution. Principles in regard to judicial review of administrative actions in general and the government contracts in particular can be summarized as follows. The modern trend points to judicial restraint in administrative actions. The court does not sit as a court of appeal, but merely reviews the manner in which the decision has been taken. The court does not have the expertise to correct the administrative decision. If the review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise, which itself may be fallible. The terms of invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in realm of a contract. Normally speaking, the decision to accept the tender or award the contract is reached by the process of negotiation through several tiers. More often than that, such decisions have qualitatively done by experts. The government have freedom of contract. In otherwise, fair play in the joints is a necessary concomitant often for an administrative body functioning in administrative spheres. Then the body in a or quasi-administrative sphere. However, decision must not only be tested by the application of Wednesbury Corporation, principle of reasonableness must be free from arbitrariness and not affected by bias or actuated by malafide. Quashing decisions may impose heavy administrative burden on the administration and lead to increased and unbudgeted expenditure. But I will place the relevant paragraphs as well. If your lordship now comes to the second part, my lord.
Yes.
Two tests to determine the extent of judicial interference in tender matters are as follows. Whether the process adopted or decision made by the authority is malafide or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court says the decision is such that no responsible authority acting reasonably and in accordance with the relevant law could have reached, whether public interest is affected. If the answers are negative, kindly note, my lord, there should be no interference under Article 226. Cases involving blacklisting and imposition of penal consequences of the tender contractor for decision of state such and such grant of license stand on different footing as they may require the higher degree of fairness in action. Whether a term of NIT is essential or not is a decision taken by the employer which is not respected, which is to be respected. But here is a particularly identical case that has come up. But from day one, my learned friend has been giving on false informations. He has been continuously fabricating documents. No, not fabricating documents. He was giving false information to the tendering authority. On every step of the tendering process, he was saying that all his tank trucks are free and available. Whereas on the contrary, it was under a contract with IOCL. It was running even after issuance of LOA. It was also raising invoices even after issuance of LOA and generating money out of it. Whether the term of NIT is essential or not is a decision taken by the employer which should be respected. However, if an employer has exercised the inherent authority to deviate from the essential term, such deviation has to be made applicable to all bidders and potential bidders. The contention of the respondents that the project in question being infrastructure such and such, but I take your lordship directly now to the relevant paragraphs, which is paragraph 31 to 33 and 36. Yes. But a little prior there to my lord, I wish to rely on paragraph 28. There cannot be any disagreement to the legal proposition propounded in a catena of decisions of this court, relied upon by the learned counsel of the respondents to the effect that the court does not sit as a court of appeal in the matter of award of contract, and it merely reviews the manner in which the decision was made, and that the government and its instrumentalities must have a freedom of entering into the contracts. However, it is well settled that the decision of government, its instrumentalities must be free from arbitrariness and must not be effective by any bias or actuated by malafide. Government bodies, being public bodies, are expected to uphold fairness, equity, and public interest even while dealing with contractual matters. Right of equity under Article 14 adheres arbitrariness. Public authorities have to ensure that no bias, favoritism, or arbitrariness are shown during bidding process, and that the entire bidding process is carried out in absolutely transparent manner. At this juncture, we may reiterate the well-established tenets of law pertaining to the scope of judicial intervention in government contracts. Installing computers such and such, the relevant paragraph has been quoted out in this judgment by the Honorable Apex Court. While exercising the power of judicial review in respect of contracts entered into on behalf of the state, the court is concerned whether primarily as to whether there has been any infirmity in the decision-making process. In this connection, reference may be made to Chief Constable of Northwell such and such, such and such. The power of judicial review is to ensure that the individual receives fair treatment and not to ensure that the authority, after according a fair treatment, reaches on a matter which is authorized or enjoined by law to decide or for itself for conclusion which is correct in the eyes of law. By way of judicial review, the court cannot examine the details of the terms of the contract which have been entered into by the public bodies or the state. Courts have inherent limitations on the scope of such inquiry, but at the same time, as was laid down by the House of Lords in the aforesaid case, the courts can certainly examine whether the decision-making process was reasonable, rational, and not arbitrary and violative of Article 14 of the Constitution. Now, the next paragraph is 32, where Tata Cellular is being dealt with. The principal deductible from the above are the modern trend points to judicial restraint in administrative manner. Well, there is a clearly law has been laid down. Now, the Constitutional Court in extremely exceptional circumstances will interfere in a contractual matter. The court does not sit as a court of appeal, but merely reviews the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise which may itself be fallible. The terms of the invitation to offer cannot be open to judicial scrutiny because the invitation to offer is in the realm of a contract. Normally speaking, the decision to accept the tender or award the contract is reached by the process of negotiations. They are through several tiers. More often than not, such decisions are made qualitatively by experts. The government must have a freedom of contract. In other words, a fair play in the joints is a necessary concomitant for an administrative body functioning in an administrative sphere or quasi-administrative sphere. However, the decision must not be tested by the application of Wednesbury principle of reasonableness and must be free from arbitrariness, not affected by bias or actuated by malafide. Quashing decisions may impose heavy administrative burden on the administration and lead to increased and unbudgeted expenditure. Based on these principles, we will examine the facts of this case since they comment us to such and such. But the next paragraph is ABL has been laid down, affirmed again yet another time. From the above, it is clear when the instrumentality of a state acts contrary to public good and public interest fairly, unjustly, and unreasonably in its contractual, constitutional, or statutory obligation, it is really access contrary to the constitutional guarantee found in Article 14 of such and such. Next is paragraph 34, where Jagdish Mandal also has been dealt with. Whether the process adopted or decision made by the authorities malafide or intended to favor someone. Whether the process adopted or decision is made is so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably and in accordance with the relevant law could have reached where the public interest is affected. Now, kindly notes, if the answers are in negative, there should be no interference under Article 226. Cases involving blacklisting, imposition of penal consequences of a tender such and such standard different footing as they may require higher degree of fairness. But if your now lordship comes to paragraph 36, it was sought to be submitted by the learned counsel for the respondents relying upon the observation of central coalfield such and such, whether the NIT is essential or not is a decision taken by the employer and which should be respected. However, in the said judgment also, it is observed that if an employer has exercised inherent authority to deviate such from the essential term, such deviation has to be made applicable to all people. This is not the case over here. There is no deviation. But if your lordship now comes to the second quoting of that paragraph 48, therefore, whether the term of NIT is essential or not is a decision taken by employer, which should be respected. Even if the term is essential, the employer has inherent authority to deviate from it. However, the term here, this deals with another part of it, which perhaps is not applicable in our case. But here, my lord, to sum up, my lord, but I have also, I also intend to rely on Agmatel and NG projects, my lord. But Agmatel is reported in 2022, volume 5, 362. But same identical view has been all along been taken, my lord. But the relevant paragraph, my lord, if I may please. But if your lordship comes to paragraph 24 straight away. But this judgment was passed, my lord, considering Galaxy, which is a parent judgment, which is by the full bench of the Honorable Apex Court, my lord. The scope of judicial review. The paragraph starts with that.
Yes.
The scope of judicial review in contractual matters, and particularly in relation to process of interpretation of the tender document, has been the subject matter of discussion in various decisions of this court. We need not multiply the authorities on the subject as suffice, as it would refer to the three-bench judgment decision of this court in Galaxy, which I just relied on as a full bench judgment, wherein amongst others, the said decision in AFCON infrastructure has also been considered, and this court has disapproved the interference by the Honorable of the High Courts in the interpretation by the tender inviting authority of the eligibility term relating to the category of vehicles required to be held by the bidders in the tender floated for supply of vehicles for the carriage of troops and equipment. But the next paragraph, my lord. The quoting from Galaxy, my lord, in a series of judgments, this court has held that the authority that authors the tender document is the best person to understand and appreciate its requirement, and thus its interpretation should not be second guessed by a court in a judicial proceeding. We may add that the owner or employer of a project having authored the tender documents is the best person to understand and appreciate its requirement and interpret its document. The constitutional courts must defer to this understanding and appreciation of the tender documents unless there is a malafide or perversity or in the understanding or appreciation or in the application of the terms of the tender documents. It is possible that the owner or employer of a project may give an interpretation to the tender document that is not acceptable to the constitutional courts, but that by itself is not a reason for interfering with the interpretation given there. But the next paragraph, my lord, I intend to rely on, my lord, continuing with that. But the paragraph 20 of Shilpi construction, which has been laid down, paragraph 16 and 20, the essence of law laid down in the judgments.
Yes.
Referred to above is the exercise of restraint and caution, the need for overwhelmingly public interest to justify judicial intervention in the matters of contract involving the state instrumentalities. The court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of its requirement, and therefore court's interference should be minimal. The next paragraph, if your lordship comes to, continuing that, but it starts with, my lord, judicial review of administrative action, 22, paragraph 22 of the other judgment. Jagdish, yes. Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether the choice or decision is made lawfully and not to check whether the choice or decision is sound. Well, here we are at a place where lordship is exercise lordship's discretion on the second limb of it, where power of judicial review is invoked. The matters relating to tenders or award of contracts, special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essential commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide, as in the public interest, court will not exercise the power of judicial review interference, even if the procedural abbreviation or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to process private interest at the cost of public interest or to decide contractual matter. Here is a case which my learned friend is trying to put in himself. He is trying to put in a private interest over the realm of a bigger interest of the authority. The tenderer or the contractor with grievance can always seek damages in a civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be restricted. Such interference, either interim or final, may hold a public work for delay or delay relief or secure to thousands and millions and may increase the project cost manifold. Therefore, the court, before interfering in tender or contractual matters in exercise of judicial review, should pose itself to the following questions: whether the process adopted or the decision made by the authority is malafide or intended to favor someone. To this, my answer is squarely negative, and that is evident at the face of it. Whether the process adopted by the decision made is so arbitrary or irrational that the court can say the decision is such that no reasonable authority acting reasonably and in accordance with relevant law could have reached, whether public interest is affected. If the answers are in negative, there should be no interference under Article 226, cases involving blacklisting such and such. If your lordship now comes down further ahead, paragraph 19 of Monte Carlo has also been laid down. I will not trouble your lordship by placing the entire paragraph because same principle has been followed. Only the bold part, if your lordship sees, but where a decision is taken that is manifestly in consonance with the language of the tender or serves the purpose for which the tender is voted, the court should follow the principle of restraint. Technical evaluation or comparison by the court should be completely impermissible. But the next paragraph, if your lordship comes to, is paragraph 26. The above mentioned facts. The above mentioned statements of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate its requirements, and if its interpretation is manifestly in consonance with the language of the tender documents or subserving the purpose of the tender, the court should prefer to keep restraint. Further to that, technical evaluation or comparison by the court is impermissible, even if the interpretation given by the tendering authority document by the person inviting tender is not as such acceptable to the constitutional court. That by itself would not be a reason for interfering with the interpretation given. Applying to the aforesaid principles to the case at hand, we are clearly of the view that the impugned order cannot be sustained. But now if your lordship comes to paragraph 31, it has rightly been pointed out by the appellants with reference to the decision of AFCON that in interpretation by owner or employer of a project to the tender document may not be acceptable to the Constitutional Court, but that by itself would not be a reason to interfere with the interpretation given. But if your lordship now takes up once paragraph 31.1.
Yes.
4 lines from the top from that paragraph, in given set of facts and classifications.
Yes.
The decision as taken by NVS and its TEC cannot be said to be suffering from irrationality, absurdity, or malafide. In our view, the analysis of the Reed Court needs to stop at that. Beyond this point, the Reed Court would not be substituting its preferred interpretation of the tender conditions with the one adopted by the author of the tender documents and the person procuring the product who has regarded it as a best person to understand its requirement. So, the law at this juncture is very well settled. There is NG products as well, but I need not trouble your lordship by placing the entire judgment. I will only indicate, my lord, the relevant paragraphs. These all falls down from Galaxy. Your lordship is well aware of. But in NG, my lord, NG projects, my lord, paragraph 12. NG 2022, volume 6, SCC 127. But if your lordship kindly comes to paragraph 13, the Shilpi is here. The Shilpi has also been considered, my lord. Shilpi construction in paragraph 13.
Yes. Tata Cellular paragraph 10.
Yes, my lord, paragraph, yeah, and then paragraph 14, if your lordship sees, the Monte Carlo is again been considered, my lord. If your lordship now next comes to paragraph 15. Reflex, my lord. Only 2 lines of this paragraph I will place, my lord. The objective was to have a greater transparency. My lord, 3 lines from the top, my lord.
Yes.
And the consequent right of an aggrieved party to invoke the jurisdiction of the High Court under Article 226 of the Constitution of India beyond the issue of strict enforcement of contractual rights under civil jurisdiction. However, the ground reality today is that almost no tender remains unchallenged. Unsuccessful bidders or parties not even participating in the tender seeks to invoke jurisdiction of high courts under Article 226. The court has held the judicial review of such tender matters has its own limitations. It is in context of judicial review of administrative actions that this court has opined that it is intended to prevent arbitrariness, irrationality, and arbitrariness, unreasonableness, bias, and malafide. The purpose is to check whether the choice of decision is made lawfully and to check whether the choice of decision is sound. In evaluating tenders and awarding contracts, the parties are to be governed by principles of commercial prudence. To that expense, my lord. But the next is been set out, my lord, which I had already placed, my lord. There are certain contractors who make a mole out of a hill, my lord. The next important paragraph, if your lordship takes into consideration, paragraph 16. Yes, my lord, Galaxy. Galaxy has been well laid down here, my lord. But the concluding paragraph is paragraph 23, my lord. In view of the above judgments, paragraph 23.
23. Yes.
In view of the above judgments of this court, the Reed Court should refrain itself from imposing its decision over the decision of an employer as to whether or not to accept the bid of a tenderer. The court does not have the expertise to examine the tender and conditions of the present day economic activities of the state, and this limitation should be kept in view. The court should be even more reluctant in interfering with the contracts involving technical issues as there is a requirement of necessary expertise to adjudicate upon such issues. The approach of the court should not to find fault with magnifying glass in its hand. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender condition. If the court finds that there is total arbitrariness or that the tender has been granted in a malafide manner, still the court should refrain from interfering in the grant of tender, for instead relegate the parties to seek damages for wrongful exclusion rather than to injunct the execution of the contract. The injunction or interference in tender leads to additional cost on the state and is also against public interest. Therefore, state and its citizens should suffer twice. Firstly, by paying escalation costs. Secondly, by depriving of the infrastructure for which the present day governments are expected to work. But to sum up, my lord, I had already placed in detail the other day, my lord. From day one, my lord, they have been giving false informations. But when the after award of the LOA, when the trucks were sent for inspection, that time also I had handed over those fact sheets, my lord, in which they have indicated that the trucks are not employed with anyone in there. But it got detected when IOCL had indicated and wrote to us that these tank trucks are already flying with us under a contract. So how can these be inducted? Thirdly, the purported NOC, which my learned friend is relying upon, that NOC has been granted, that NOC is to the extent of participating in the tender, not releasing of the vehicles. And the NOC also indicates in the second part of it that in the event you are successful in being awarded in a contract, you have to replace those tank trucks with another set of tank trucks so that this contract should follow. But there is no scope of interim order at all, my lord. Lordship can hear out and decide the writ petition itself, my lord. This is a fair fit case, my lord. The writ petition is liable to be dismissed, my lord. These are my submissions.
Okay.
I was watching the clock. After almost conclusion of my submission as reply, it took another 25 minutes.
Point of law, my lord. After reply also I can take it. Point of law, not on facts. My learned friend will also confine his reply to the point of law only. We can't go into the facts at this juncture.
But I shall take 20 to 25 minute time according to my way. Possibly my learned friend will not disturb me because I have not.
Okay.
The issue is that, my lord.
But if my learned friend argues on point of law, certainly.
Okay, on the point of law. Yes.
Just narrating the brief facts.
Yes.
Tender has been floated with the condition that a candidate can offer attached vehicles of other oil companies. But he has to submit a NOC at the time of induction. Kindly take note of induction.
Yes.
Clause 6, page 112, General Terms and Conditions. Says at the time of induction of the vehicles, you have to produce NOC from the other oil company. What happened in this? I participated in the selection process.
Yes.
By offering 6 attached TTs and 2 free TTs.
Yes.
Admittedly, in the prescribed application, I have given a false statement that all TTs are free TTs, including those 6. Paragraph 7 and 8 of my writ petition categorically says why I have been prompted. Because I have shown to your lordship, I have not been given any priority, not higher marks, not any relaxation, nothing. Then prudent man will ask why you have done so. I have done so. IOCL with no uncertain term gave me an email saying that by 10th we shall release all. Kindly take note page 7 and 8 of my writ petition.
Yes.
I have categorically stated in page 7, paragraph 7, that had I been disclosed that these 6 TTs are attached TTs, and on the latter part of the day, these TTs are being released by the IOCL, there should have been a false information. That prompted me to disclose in my application that all TTs are free. This has been considered by the division bench. I shall already shown, just one line I shall show.
Yes.
Then, my lord, out of 8, 6 have been selected and offer letter has been issued. Out of 6 attached, 4 and 2 free. On 18 December 2024, offer letter has been issued at page 382. I have received it on 2nd of January 2025.
Doesn't have to read on his case, my lord.
This is unfortunate. This is very unfortunate.
I know.
This is very unfortunate.
Yes, my lord, has to be.
Okay.
But he will be Loser case, you will jump and say,
Let me lose on a limited extent.
there are 13, page 10.
Not by
I have
rerunning
categorically
indices.
stated, I have received it on 2nd of January 2025. What was the instruction in the offer letter? 3 instructions. Just take that document. Page 382. What is the instruction? This is only important in this case. Whether I have followed the same or not. Kindly take page 382, need not page 383. Page 383.
Yes.
You are requested to come forward immediately for completing the following formalities. Kindly submit performance security of rupees so-and-so. Please bring the original documents of owner attached tank trucks offered in the tender. You are required to complete the above formalities. General terms and conditions. So I have to deposit the security money and I have to produce all documents including carryable certificate and registration certificate, everything. And I have to produce the vehicles also before the authority concerned.
Yes.
There was no direction that I have to produce, my lord, NOC. NOC is in terms of page 112 at the time of induction, which is a latter part. Terms and conditions says I have to comply the offer letter terms and condition,
Yes.
which suggest you have to deposit the security money, you have to place all vehicles, you have to show SC, ST certificates and calibration certificate, fitness certificate, registration certificate of the TTs. Admittedly, all I have done. There is no dispute in this regard also. I have deposited the 8 lakhs as security money. I have placed all vehicles, all documents in connection with my vehicles, that is registration certificate, calibration certificate, everything. There is no dispute, admitted position. Physically placed all the vehicles, 6. Then agreement has been executed. Take note of. Only after completion of all these formalities, agreement can be executed. That is page 390. Now, before induction, termination. Can you take note of?
Yes.
Page 390 is the agreement I have annexed, model copy.
Yes.
On 11th February 2025. Thereafter, not a single document oil company has been produced or shown to your lordship that there is a direction for induction of the vehicles.
I raise very strong objections. Well, then I will also have a reply to reply and this will continue.
Not necessary. He just
My learned friend is again getting back to facts. I'll again deal with the facts.
not necessary. I have already deal with the entire matter.
Now,
Yes.
your lordship, kindly take note the termination order straight away. It starts from page 414. What is the clauses for termination? Kindly turn to page 416. But kindly take minute from bottom 3rd paragraph. 3rd line. On interest-wide basis under clause 8.2.2.14, have you lordship got my lord?
Yes.
8.2.2.15 and 8.2.2.16 of the brochure. Terms and condition. My learned friend has handed over your lordship that document. Kindly take note of, my lord, the Oil Industry Transport Discipline Guideline. What process says? I am not relying any other document. Only termination order, invoking which provisions they have terminated my license, blacklisted, and entire security money has been taken away. Kindly come to page 24. These are the clauses they have disclosed. Page 24, kindly come to the bottom. 8.2.2.14. Have you also got my lord? Page 24 of the
Yes.
discipline guideline. 8.2.2.14, unauthorized use of TT outside the contract. What will be the punishment? TT concern shall be blacklisted. The particular TT. Am I clear to your lordship?
Yes.
Then 8.2.15. Entering into contract based on forged documents, false information. In respect of all TTs, why I am saying so, I shall show from the next page. Entire fleet along with carrier to be blacklisted, SD to be forfeited, and transportation contract to be terminated. Then B is very important. Submission of forged document during contract period. Concerned TT shall be blacklisted. they have only actually invoked my lord 8.2.2.16. Kindly take note of. Entering into an agreement for the same TT with other oil companies. Concerned TT shall be blacklisted. 8.2.2.16 has been invoked by the oil company. At best or at worst, they can blacklist 4 TTs and they have to allow me 2 TTs, the 3 TTs. Kindly take note of my division bench judgment. I shall not elaborate my submission. Justice Joyamalla Bakshi and Justice Kant.
Yes.
Well, paragraph 18 at page 11. Entire thing has been considered in a worst case, much inferior case. Kindly take note of paragraph 18 at page 11. You also got that?
Yes.
Initially, the show cause notice called upon the writ petitioner to submit documents to justify the declaration of month and year of manufacture of 7 out of 14 TTs offered by them. But in this case, what happened? There are charges that 10 TTs are not operating, so that has to be blacklisted. And out of that, 7 was functioning. Writ petitioner submitted documents and the oil company was satisfied there was no incorrect declaration with regard to the 6 TTs. However, the month and year of manufacture of 1 TT, being registration number so and so, was found to be incorrectly made in November 2011 instead of October 2014. Kindly take note of. This is the crux of the case. In that case, one of the TT has been disclosed registration number October 2011, November 2011, instead of October 2014. Your Lordship knows if 2 bidders gets the same marks or their rate is same, then manufacturer will be the only consideration.
Yes.
In a calculative manner, undue advantage sought to be taken in this case. That has been dealt with by the division bench. Registration date is 2011, it has been shown as 14. So it has been sought to be placed that a new vehicle has been produced. Then, as per clause 8.2.213 ITDG, this would justify the blacklisting of TT only. Kindly take note, only TT only. However, Mr. Nag relies on a subpara in clause 8.2.2.2, which entirely provides in case of complicity of the contractor is established, even in first instance of malpractice. Kindly take note of. This clause has not been relied on so far our case is concerned. Even then, entire fees shall be blacklisted, contract terminated, and security deposit forfeited. He also relies on clause 19 of the tender conditions, which entirely provides in case of false, forged information is detected, subsequent to error of contract, the contract is liable to be terminated. Aforesaid clauses make it amply clear mere submission of a forged false information with regard to one or some of the TTs, but in our case 4 TTs at best out of 6, would not ipso facto lead to termination of the contract as a whole or blacklisting of the entire fleet. It must be borne in mind that an order of blacklisting on an industry basis would tantamount to commercial death of the contractors. This extreme penalty is reserved for those egregious cases where the oil company is able to establish complicity of the contractor in the malpractice. The word complicity means active connivance or participation in wrongdoing or a crime. That is to say, fake document or false information relied upon by the contractor must be used with the requisite intention to deceive or defraud or the oil company and thereby gain unfair advantage. Kindly take note of. Had I been given any undue advantage for providing or saying that these 4 TTs are not attached? Is it a crime? Any extra benefit, any extra privilege, any additional marks? Answer is no. Whether it is attached or not, immaterial to the fact so far the selection is concerned. This is the division bench judgment. Next paragraph. Next paragraph. fake registration, certificate and document month and year of manufacture of one of the TTs as November 2014 instead of 2014. It would be 11. It is for the oil company to establish that this false declaration, if detected, had deceived the company and helped the contractor to gain unfair advantage. My learned friend not uttered a single word that for providing such false information, I have given some extra advantage. Next paragraph. Mr. Nark argued that false declaration helped the petitioner in offering the batch of TTs on an 1.8 ratio, and thereby secure first position. Kindly take note of. Writ petitioner had offered 2 trucks in 18 to 20 kiloliter and 16 trucks in 12 to 16 kiloliter category. The offers in the respective categories were based on the capacity of the trucks and not the age of their manufacture. Next paragraph. As per the tender conditions under the heading ranking in lot system, age of the manufacturer is relevant only when the contractors in lot 1 offering trucks in the 2 categories also are jointly ranked in the top. It is nobody's case that Joy Matadi, he is the next one. The other contractor was ranked at the top along with the petitioner. Kindly take note of. There is a calculative intention. If another contractor gets the same marks, then my age of vehicle will be considered, and accordingly, I have provided wrong information that it has been registered in 2014, not in 2011. But the division bench considered it that since there is no other person got the same marks, he did not get any advantage, even he tried to. Kindly take note of, even he tried to. But ultimately, for this wrong information, he didn't get any advantage.
Yes.
In my case, there is no second person, and I didn't get any advantage for providing wrong information. Admitted position. That is not the case of the oil company. Next page. In this backdrop, incorrect declaration with regard to the month and year of one of the TTs by the writ petitioner did not give any unfair advantage to secure the contract. Entirely our case. On the contrary, such declaration, if detected, would visit him with undesirable consequences. In such view of the matter, it believes logic with a prudent businessman would intentionally provide false information with regard to the month and year of manufacture of his TT and express himself to unnecessary disqualification. Paragraph 7, I have disclosed why, which have been prompted me to provide this information. Written assurance, within 10, we shall issue the NOC. Paragraph 7 and 8 of my declaration.
Yes.
And documents also, all emails. The aforesaid factual matrix clearly shows the incorrect declaration with regard to the TT in question was either due to reckless overzealousness without any practicable benefit to the contractor or sheer negligence on his part. No doubt this would visit him with the penalty of blacklisting of the TT concern, but cannot translate it to a case of complicity, which would entail cancellation of the agreement as a whole and blacklisting of the entire fleet. Respondent authority failed to consider these relevant factors and mechanically cancelled the entire agreement and blacklisted the entire fleet. In the light of the aforesaid facts, we are constrained to oversee though wide order termination of the contract and blacklisting of 10 TTs. 10 TTs was irregularly operating, not reporting properly, including the one in respect of which false declaration was made in justified. There is no justification for the imposition of extreme penalty of cancellation of the agreement as a whole and blacklisting of the entire fleet so and so. Total 15 vehicles, 10 irregular reporting, 1 false information, rest 4, kindly come to the next page. Accordingly, we modify the impugned order of termination and en bloc blacklisting and direct that same shall operate with regard to 10 TTs in question. Writ petitioner shall be permitted to apply 4 TTs as per the agreement. 10 TTs was not reporting regularly, one of them false information. These 10 TTs should be blacklisted. So far 4 is concerned, no wrong information, they should be allowed to continue. Yes. This is the division bench order. Taking note of that no extra benefit has been given. My learned friend on last occasion, and this is the single bench judgment, considering that judgment, your lordship kindly see, Poshanto Soren, relying on this division bench judgment. I am also much better than that case also. WPA 8707.
Yes.
May I have yours? But straight away come two paragraph, page 6 first.
সে তো আমি চারটে মামলা আরো করেছি তাহলে কি reply stage again another judgment না I will fairly argue out the
I
matter.
placed on last occasion.
It was placed earlier.
কোনটা?
What is shorted? Shortangshu was. I should not place a single document.
কি বলছে প্রশান্ত বলছে?
প্রশান্ত শোনেন তুই যেটা করেছিস আগে তুই প্লেস করেছিস আমি রসের কাছে রয়েছে
Yes.
Oh, I am not that boy that I shall place a new document without handing over your copy. Kindly come to page 6, my last paragraph.
Yes.
In considering the prayer for interim protection, it appears to that the law has been settled by the Honorable Division Bench Committee. Well, that judgment, just I please. That the oil company cannot terminate the entire contract, though some of the treaties were not placed properly. I thought that was the answer, then next page, my lord. Last part, third paragraph. Under the above observation, petitioners deserve interim order. The interim order passed by the concerned authority be hereby stayed for a period of 8 weeks. The respondent authority shall allow the petitioner to carry with the agreement for rest 7 trucks. 8 trucks produced. Once registration number false, that has been blacklisted, court directed, allow them to 7, run 7. On last occasion, my learned friend also submitted, although it is not required to be placed before your lordship, that 2 treaties out of 2, 1 is not free. Kindly take that document. This is also not the impugn order. I should not have placed, even then I am placing it. Kindly take note of. These are the 2 documents, 2 vehicles. Request to remove our 2 additional TT or so and so, WB number, registration number, I shall show to your lordship, page 382. These are the registration number. This is a letter, email of November 14. Have a lordship got my lord, right hand side? November 14. Kindly read. Ajan Logistic to Oil Company, Dotto, to Gupta. Dear sir, this is to inform you that we placed 2 TTs at your Bajbaj report at temporary loading. Temporary, no agreement, only temporary loading. So I request you to kindly remove the both TTs number so and so and so and so. Your lordship will get the number, serial number 5 and 6, page 382, their document. As soon as possible, because we want to apply the same TTs on other oil company. Kindly take the reply.
This is not our document. This is a correspondence between IOCL and my learned friend.
Absolutely.
Not our document.
Page 382 gives the registration number of the vehicles. Kindly read. Heard what I am going to say. Kindly say removed. When removed? On 14th itself, 11:13 AM. 14th, it's a temporary loading released on 14th November, removed. Although it is not the order impugned, they are only considering 4. Even I am showing, since it has been made submission from the bar, that 2 TTs are not yet free. I am showing your lordship oil company's intimation, IOCL, 14th November 2023. Your lordship will check the number from page 382, serial number 5 and 6. Same TTs. Registration number 382. May I press before lordship the registration number?
Yes, registration is there.
Yes, this registration number will tally from their document, page 383.
Yes.
Your lordship knows just one line. The Mahinda Singh Gill, 1978 1 SCC, page 405. That respondents cannot make out a new case which is not in the order impugned. This is a settled principle. I am not placing that judgment. Now the judgment today have been placed. I am thankful to my lord, my learned friend. Whatever judgment he has been placed before lordship, it says Wednesday is principle of reasonableness. This is our case. All judgment says if there is unreasonable, vice versa, unfairness, arbitrariness, court has ample power to struck down the decision of the oil company or any tenderer. None of the judgment says unreasonable should be accepted, arbitrariness should be accepted, unfairness should be accepted. There should not be any transparency. Whatever judgment till today all says court has enough power to interfere with the decision of any authority if there is unfairness, unjustness, arbitrariness, or not any transparency. This is a case where I didn't get any advantage. Whatever I have done for 4 TTs. My 2 TTs is free altogether. That should be allowed. The order of impugn, termination of entire agreement, blacklisting, and security deposit should be stayed like the order passed by your lordship in the subsequent to the division bench order. These are my prayer.
Yes.
2 lines, my lord.
This is possibly, my lord, not permissible. This is not possible. No, I should not. I am objecting. I am
Page 408,
I am
your lordship sees.
I am objecting this, my lord.
My learned friend says that on 14th of November 2023, my lord, this document is coming at 11:40 at the reply stage, my lord. But I will show more falsifying facts, my lord. At
Let him show, my lord, from the affidavit. Not from my chair.
408 of the writ petition, my lord, kindly
I
see.
don't know, my lord,
Not
how your
paragraph.
lordship is allowing him. Reply.
I have heard entire matter.
Your lordship,
410, my lord.
Whatever. It will never be concluded. Then I shall again make my
The
submission.
learned friend will keep on arguing.
No, definitely.
He will be at a reply stage, he has all the right.
What you want to demonstrate? What is the
My lord, he is purporting to assert that on 14 November
This is not, I am not relying on, because this is not the order impugn. I am not relying on.
he handed over
I
a
am not
document
relying
and
on.
he says
Yes,
that I am
what you
not
say?
relying on.
What do you say?
I say that in the reply to the show cause, they give a reply that however, due to some pending formalities, such TTs could not be released, and we have been given firm assurance that all formalities will be concluded by 9/4/2028
Respect of 4 TTs.
without further delay of any 4 treaties, my lord.
This is the reply to the show.
In respect of 4
But
TTs.
this is an email of 23 and this is a reply given in 2025 March. Kindly see the falsifying stance that always have been taken.
This is in respect of
And
4
my-
TTs. I am always saying I have given
And my
false
learned
information.
friend have been saying with very loud voice of unfair advantage. LOA was being issued. Thereafter, trucks kept on plying. Invoices kept on being raised. Payments kept on being received. Whether that's an unfair advantage accrued or not, lordship will decide. I have indicated as late as February 2025, my lord, the trucks were continued to ply with IOCL. Invoices were being raised, my lord, and payments have been received.
Okay.
তুমি বললি বলো তুমি না বললে বলবো না অফলাইন পিটিশনের হয়তো করলে করতে হবে
And may come back first.
Yes.
Huh? Reply করছি।
Please take down.
নোটিশ দিয়েছে না ঠিক না আসলে ঘটা আসছে
Hindustan Petroleum Corporation Limited, within bracket HPCL, floated e-tender for transportation of bulk white petroleum product, within bracket capital MS stroke HSD, by road X hyphen Modigram TOP by the tender document dated 28th of September 2024. Full stop. The petitioner participated in the subject e-tender floated by the HPCL by offering these 8 numbers of owned truck tankers within bracket TTs. Full stop. It is the case of the petitioner that at the time of participation in the said tender, petitioner offered 8 TTs to be all free TTs, comma, that is to say, none of the TTs are attached with other oil companies or engaged attached engaged with other oil companies. Full stop. It is the positive assertion of the petitioner that amongst the 4 TTs, amongst the 8 TTs, 4 TTs were engaged with Indian Oil Corporation Limited within bracket IOCL, who assured through official communication that on 9th of October 2024, the 4 TTs would be released. Full stop. On the basis of their assurance, the petitioner participated in the tender, stating the fact that all the 8 TTs are free TTs. So after compliance of the formalities, HPCL, formalities, comma, the petitioner being successful, HPCL authority had issued provisional letter of acceptance in favor of the petitioner on 18th of December 2024 in respect of his 6 TTs. Full stop. In terms of the said letter of acceptance within bracket LOA, petitioner placed all 6 TTs, including particulars, and also submitted the security deposit with the IOCL. Full stop. At the time of induction, it appears to the it appears to the HPCL authority that amongst 6 TTs, 4 TTs are already under the valid contract at IOCL. Accordingly, the IOCL has issued a show cause notice upon the petitioner containing alleging inter alia that এটা করো 406 এই মার্ক পোর্শন এটা করো হ্যাঁ হয়েছে মার্ক পোর্শন হয়েছে petitioner replied to the so cause and it has been specifically stated in the said reply that paragraph last paragraph of 40 page 40410 এখানে দেখো দেখে first paragraph first paragraph of 411 আছে 410 last paragraph 411 first paragraph আছে after receiving such so called reply to the so called hearing was conducted petitioner participated in the said hearing thereafter on 10th of April 2025 impugn order of termination was issued by the concerned authority as follows করে তুমি 416 টা তোলো এই ঠিক আছে এইখান থেকে 416 challenging the impugned order of termination issued by next further issued by the HPCL, the instant writ petition has been preferred. Full stop. Learned counsel, learned senior, Mr. Devabrata Sahara, learned senior counsel, appearing on behalf of the petitioner, submits that the impugned order of termination is baseless and not reasonable. He submits that the concerned authority has acted malafidely in passing the impugned order of termination. At best, he further submits that at best, the 4 TTs which were attached with the IOCL can be blacklisted or not allowed to be operated, but entire fleet cannot be blacklisted. He further submits that the 2 TTs which are plying, 3 TTs which are plying with the HPCL may be allowed to continue in terms of the agreement. Full stop. In support of his contention, Mr. Sahara has placed a decision of Honorable Division Bench of this court passed in IOCL versus Ajit Kumar Murmu. within bracket MAT 1905 of 2024. Mr. Sahara submits that the Honorable Division Bench, in a similar set of facts, wherein the information of a truck tank given by the tenderer appears to be false. What appears to be false, by which the concerned oil company has terminated the entire fleet by blacklisting it. The Honorable Division Bench, on the same set of facts, has observed that paragraph 19 paragraph 18 and 19 set of call. Mr. Sahara also placed a decision of this court in Prashanto Soren versus Hindustan Petroleum Corporation Limited and others, wherein this court also has taken the similar view and passed an interim order in respect of an order of termination passed by the HPCL, where the tenderer failed to produce some of the TTs according to the stipulation of contract. Full stop. This court has also directed the concerned authority to carry with the agreement for arrest-free track tankers. TT বড় হবে. Mr. Sahara has argued clearly and unequivocally that the petitioner was misguided by the IOCL authorities. Thus, he placed the tender showing that all the TTs are free TTs. Mr. Sahara further argued that the petitioner was under impression that before submitting the tender document, the TTs would be free. TT would be free. He submits that no malified intention or advantage or misrepresentation as demonstrated in this case shall entail the petitioner in any advantages in the tender. Thus, the conduct of the petitioner can also be termed as a unintentional laches, and the petitioner may be allowed to ply 2 free TTs except the 4 TTs which were engaged with IOCL. So he prayed for an interim order in this matter. Full stop. Mr. Vishwanath Chatterjee, Learned Counsel, appearing on behalf of the HPCL, initially submits that this writ court has no jurisdiction to entertain the writ petitioner. Mr. Chatterjee, to entertain the writ petitioner, full stop. Mr. Chatterjee further submits that there are no error apparent in the order itself. Moreover, the order passed by the concerned authority is not at all unreasonable. Mr. Chatterjee has placed the LOA and the copy of agreement. He submits that the letter of acceptance within bracket LOA has specifically mentioned that if the tenderer failed to comply with any formalities mentioned in the contract agreement as well as the LOA, the letter of acceptance may be cancelled and necessary action can be taken by the authority. Full stop. He further submits that admittedly the petitioner had stated falsely that all the 8 TTs are free TTs. Admittedly, amongst the 6 TTs in favor of which the LOA was offered, 4 TTs are engaged with other oil marketing company within bracket IOCL. The intention of the petitioner, he submits that the intention of the petitioner can be gathered that he tried to apply the 4 TTs simultaneously with 2 oil companies. Full stop. He submits that as there is no arbitrariness in passing the impugn order of termination by the HPCL, thus the writ petitioner has no scope to challenge the order of termination before this writ court. He further submits that the writ petitioner never informed the authority regarding the attachment of 4 TTs with IOCL. Rather, when all 6 TTs are placed for induction with a specific agency, it noticed that amongst them 4 TTs are already engaged with the IOCL with a valid contract. Mr. Chatterjee has also placed the oil industry transport discipline guideline OITDG and the relevant provisions of 8.2.2.14, 8.2.2.15 and 8.2.2.16. 8.2.2.16. 1.6 না 16 16 হ্যাঁ 8.2.2.16 ঠিক আছে to justify the act and action of the concerned authority. Mr. Chatterjee heavily relied upon the decision of Honorable apex court regarding scope of judicial review by a high court under Article 226 of Constitution of India in a tender process. He placed the decision of Honorable Apex Court as follows. One, Lekho. Bansidhar Construction Private Limited versus Bharat Coking Coal Limited and others. Bracket Lekho 2024 10 SCC 273. Second Lekho NG Projects Limited versus Vinod Kumar Jain and others within bracket 2022 6 SCC 127. Agmatel India Private Limited versus Resources Telecom and others within bracket 2022 5 SCC 362. Full stop. For the learned advocates, peruse the observation of Honorable Apex Court in the decision in the judgments as relied by Mr. Chatterjee. The Honorable Apex Court, in deciding the issue of judicial interference and judicial review in the tender process, has detailed about different judgments of Honorable Apex Court. In Silpi Construction Contractors versus Union of India judgment which Galaxy Transport Agency versus New JK Roadways within bracket 2021 16 SCC 808. Tata Cellular versus Union of India within bracket 1994 6 SCC 651. Jagdish Mandal versus State of Odisha within bracket 2007 14 SCC 517. Afcon Indus Infrastructure Limited versus Nagpur Metro Rail Corporation Limited, 2016, within bracket 2016, 16 SCC 818. In Silpi construction, the Honorable Apex Court has held that paragraph 20 টা তুলবে এইখানে। আচ্ছা, এই paragraph 20 টা তুলবো, এই এতটুকু mark portion. In Jagdish Mandal versus State of Odisha, the Honorable Apex Court has held that para দিয়ে করবে। Paragraph 22 এইটা কি পাবে না, এইখানটা দেখতে হবে, ওই জাজমেন্ট গুলো থেকে তোলা আছে, এই যে এখান থেকে তোলা, এই যে এই মার্ক পোর্শন দেখেন, হ্যাঁ ঠিক আছে, হ্যাঁ এইখানটাই 1 2 1 2, হ্যাঁ দুই হবে। দেখো নেক্সট করে in NG Projects Limited, the Honorable Apex Court, after considering the all relevant judgments of Apex earlier judgments, has held that paragraph 23, paragraph 23, এটা কত নম্বর হবে, 3, আচ্ছা। In Tata Cellular versus Union of India, the Honorable Apex Court has decided the issue of principle where High Court can entertain a read petition regarding judicial review of administrative decision under Article 226 of Constitution of India as follows. এটা কত বললাম, 3 4 5 portion এতটা তো করে paragraph 32 আছে পড়ে, হ্যাঁ Mr. Chatterjee, after referring all the judgments of Honorable Apex Court, has submits that the Honorable Apex Court has made clear of the fact that if the decision of the authority is not arbitrary, there is no scope of judicial interference, judicial review and the interference of a high court under Article 226 of Constitution of India. He further submits that in the present case, the petitioner has stated falsely, from its inception that all TTs are free TTs, but fact suggests that 4 TTs are engaged with. Suggests that the 4 TTs are engaged with IOCL. Hence, the decision of the authority cannot be said to be arbitrary or perverse. He submits that the entire writ petition is liable to be dismissed. Having heard the learned counsel for the parties and considering the entire matter, it appears that the concerned authority has terminated the agreement of the petitioner with the HPCL in terms of clause 8.2.2.2.15, 8.2.2.15, 8.2.2.16. For better understanding, the clauses under oil industry transport discipline guideline required to be set out. বলে এইরকম করে সেট আউট করবে দেখো 8.2. এটা আর একদম এতটা পর্যন্ত এইটা ঠিক আছে, তিনটে যেরকম ঘর করা আছে ওইভাবে তুলবে, যেরকম বক্স আছে সেই বক্সেই তুলবে। তাহলে এটা করবো 5, তাই তো? এটা 5 করবো। Mr. Sahara argued that in terms of those clause, the unauthorized TTs which were engaged with the IOCL may be blacklisted, not the entire fleet. Fleet FLWT. Mr. Chatterjee submits, on contrary, that the petitioner has stated falsely at the time of participation of the tender. Thus, his agreement as well as the LOA liable to be cancelled. Thus, the impugned order of cancellation is justified. Full stop. It appears that no. It appears from the division bench observation of the division bench that mere submission of forged or false information with regard to one or some of the TTs would not ipso facto lead to termination of contract as a whole or blacklisting the entire fleet. Full stop. It appears that in deciding the issue before the Honorable Division Bench, the fact suggested before the Division Bench is that the tenderer has placed one TT to be registered, one TT stated to be registered in October 2014, though it was registered in November 2011. Full stop. Such false information led to the oil companies to terminate entire fleet of the contractor. Full stop. The Honorable Division Bench has specifically observed that the complicity of the contractor was not proved in that case. The contractor, it was before the Honorable Division Bench that by placing a TT, wrongly saying that it was newly registered, cannot entail him any gain in participating the tender. Thus, the Honorable Division Bench has observed that the false information, as stated by the contractor at the time of participation of the tender, thereby has not gained any unfair advantage in favor of the petitioner, in favor of the tenderer, in favor of the tenderer. In the in the present case, the fact situation suggests that admittedly at the time of participation in the tender, the petitioner petitioner was aware about the fact, aware that 4 of his TTs were engaged with IOCL. Full stop. The provision is made in the tender document that the tenderer can place attached TTs also. But in this case, the petitioner has specifically stated in the tender document all the TTs are free TTs. In dealing with the when all the TTs within bracket 6 TTs were placed for induction, it appears that 4 TTs are engaged with IOCL. Full stop. The petitioner was issued with show cause notice, wherein the petitioner has replied that the mistake of the petitioner was unintentional and he was misguided by the act and action of other oil marketing companies within bracket IOCL, who stated that the all 4 TTs would be released. Full stop. The HPCL authority has heard the petitioner and issued the order of termination. Next, it is true that IOCL concerned HPCL authority has not considered the reply to the show cause of the petitioner and acted according to the terms of the contract. If the HPCL authority allowed to consider the reply to the show cause of the petitioner and the grounds mentioned therein regarding submission of TTs to be free TTs, and consideration thereof would be not just and proper for the concerned authorities. The terms of the agreement in the contract itself is not only binding upon the tenderer but also the oil marketing companies. The oil marketing companies are to act according to the rules and the oil industry transport discipline guidelines. If they followed to accept the explanation to the show cause by the petitioner, they would otherwise provide advantage to the petitioner. On that score, after examining on the materials on record, I am of a clear view that the decision of the concerned authority is not at all malafide or arbitrary. Furthermore, I observe that the observation of the division bench in MAT 19 in Ajit Kumar Murmu and fact facts thereof is totally different. Full stop. This court is quite dark. Why? The petitioner has not stated the fact that 4 TTs are attached with the IOCL. The tender document has allowed the petitioner stroke tenderer to disclose the fact of attached TTs. In all the relevant portions, the petitioner has disclosed that all the TTs are free TTs. The intention of the petitioner in submission of the tender document appears not to be very prudent or clear. At this juncture, I find no justification to entertain the writ petition. Accordingly, the writ petition appears to me not meritorious, and the same is hereby disposed of. Dismissed and disposed of. No, okay.
Obliged.
Okay. Thank you.
Extremely obliged.
Next.
brief গুলো দে My lord, before my learned senior friend starts, I have a point of maintainability of this matter. Whether sitting on the 226 jurisdiction, the court can alter or modify an order passed by the judicial court. That's a moot question.
Yes. What is the matter? What is the issue here?
Yes, my lord, may
I have taken the point of maintainability.
Yes,
that they have taken, my lord,
What is the
starting
issue?
from 23. My lord, they never submitted the point of maintainability. It was kept open.
No, certainly not. Mr. Bandyopadhyay is not properly instructed. From the very beginning, I have taken the point of maintainability. That has been recorded.
My lord, they never argued it. Now, today it is for final hearing. Let me start. Let them take maintainability, whatever maintainability issue they have got, my lord, after my submission.
Well, this possibly, according to my understanding, possibly not permitted. Once I taken the point of maintainability, this has to be urged first, and he has to satisfy on my point that this petition is maintainable in the present form and number. Then and only then, Lordship can go into the merit of the case.
No, Mr.
He is
Senator,
anticipating, my lord,
the,
your lordship.
maintainability is kept open.
Kept open
Yes,
long
yeah.
back.
So interim order is there running since long. Since 2020.
Well,
it is running.
interim order may be running long, right? But it has not merged with the final order.
No, I understand. But
This
the
is number one.
matter of
Number two is that once the point of maintainability has been kept open, I'm asking myself, it is not the duty of the council to get a chance to argue the point of maintainability.
No, you have the
That
chance,
opportunity,
chance to-
they have got many opportunities they did not raise. In any event, my lord, I am not shutting him out. Let them take the maintainability. Let me first open my case.
I am asking
Let
myself,
me, my lord, open my
when
case.
this matter was taken place for the hearing, this is possibly the first time
Now,
matter is
what
coming
the
up.
status of the
Kindly have a look into that. as-
pleadings complete. All
Pleadings has been complete pursuant to the Lordship's order. Now, so far this is concerned, I have a right.
Very well. Let me. You just tell me what is the matter. You
Matter
tell-
is very simple. If your Lordship kindly take trouble to see.
Mr. Bandyopadhyay start his argument after Mr. Sengupta. I shall make myself.
Okay. I will hear all the matter today.
No, that is all right.
Yes.
Lordship kindly come to paragraph 29, page 29 of the petition number Assent Deal. Assent Deal, which is WP number 28, item 9. Item 9.
Item number in the
হ্যাঁ 2896 এটা একটুখানি দাও একটুখানি
You are saying all the matters are related matters?
all the related matters I will argue on one point and I believe that will cover
Okay.
every
okay,
matter.
okay. Item number 9, page
Page 29.
Page 29.
Have your lordship got it, Milord?
Yes.
Now kindly see in what manner this mandamus has been sought for. Read in the nature of mandamus to issue directing the respondent authorities and or their main agent servants assign etc. forthwith withdraw, resign, cancel the recording order at paragraph 101 of 104 to the impugned order and judgment both dated such and such passed by the learned additional district and session judge fast track court Bosirhat, not 24 Parganas, 24 herein. Now second paragraph. Read in the nature of mandamus directing the respondent authorities and not their main agent servants and such forthwith either to release with the petitioner or in the event release the wheat is not possible to pay the petitioner current market price to the wheat in the question consequent to the recording to the paragraphs number 99 and 100 to the impugned order and judgment both dated such and such passed by learned district judge and session judge. Annexure. Now kindly come to the paragraph D. Prayer D, sorry. Read in the nature of the prohibition prohibiting the respondent and or their main servant agent assigned etc. from making any further action pursuant to the recording direction at paragraph number 101 to 104 in the impugned order and judgment both dated 202723 passed by the learned additional district and session judge fast track court Bosirhat annexure 24 paragraph such and such annexure. So this is apparent from the record that in the confiscation case they have approached the the jurisdictional court. Jurisdictional court held against them. In the judicial process or in the order, paragraph 101 and 104, this is against them. Thereby they wanted that look, what's this thing? Or you modify this thing. Once I modify this thing 101 and 104, then automatically he will be benefited to the prayer D. And 100 and 114, if your lordship kindly see, this is at page 120, 165. What is the Milord? Starts from 165. Kindly have a look into that. Prior to that, I just indicate, Milord.
What is the matter about?
I just indicate.
Why before the additional district and session judges court?
There are numbers of the trucks which is carrying the millet wheat. This wheat is not, I would say, unauthorized wheat was carrying. Now we have caught the same. Lordship knows when some goods are traveling from country to country, there has to be some proper document.
Yes.
These documents was not there. Number one. Number two, the symbols of the government was also not present on the back box of the wheat. So we have to arrest.
It was seized.
Then confiscated automatically.
Yes.
Now lordship sees the
procedure of confiscation was complete.
Confiscated complete, right?
Thereafter they challenged that.
Challenge the same before the authority.
Okay.
Now kindly see the I would not trouble your lordship for just 6A, B. Let us start from the 6B.
Yes.
Of
sure.
the it is page 47 onwards. একটা বই দিয়ে দেন না ভাই?
No, I have the book. Don't worry.
6A.
Kindly come to 6A onwards.
6A onwards.
My point is lying on the 6C. But in order to make the tune intact, I have to read the 6AB, then I have to.
Okay, proceed.
It is at page 39, Lordship has got it. Where any essential commodity is seized in pursuance of the order made under section 3 of the relation thereto, a report of such seizure shall without unreasonable delay be made to the collector of the district of the presidency town in which such essential commodity, and whether or not a prosecution is instituted for the contravention of such order, the collector may, if he thinks to expedite to do so, direct the essential commodity to cease to produce the inspection before him, and if he is satisfied that there has been a contravention of the order, may order of the confiscation of A. Essential commodity so seized, B. Packages covering receptacle in which such essential commodity is found, any animal, vehicle, vessels or other convention used in the carrying such essential commodity. Now, kindly skip over the same, kindly come to the 6B. 6B.
6B.
It is at page 47.
Yes.
Issue of notice before the confiscation of the essential commodity.
Yes.
No order of confiscation, any essential commodity packages covering or such and such animal, vehicles, vessels or conventions shall be made under section 6A unless the owner of such essential commodity packages covering reception, animal, vehicles, vessels or other conventions
Given a notice.
So naturally, this 1 and 2 part has been covered. Now we are on C,
Very good.
6C, which is at page 50.
Appeal.
Any person aggrieved by an order of the confiscation under section 6A may, within 1 month from the date of the communication to him of such order, appeal to any judicial authority appointed by the government concerned, and the judicial authority shall, after giving an opportunity of the applicant to be heard, pass such order as may think fit. This is the order which is under challenge, the order of the judicial authority. Who is the judicial authority? Kindly have a look into the section, paragraph 165 onwards. 165 onwards. Lordship, kindly note only one sentence to the same. The judicial authority.
Yes.
Have your Lordship got it, Millard? Now kindly come to the Millard, the page 165.
Yes.
Have your Lordship got it, Millard? Of my petition. Of the petition, not the book. Present such and such. Kindly have a look first. In the court, why I am saying this is extremely important, In the court of additional district and session judge, fast track court 1, Basirhat. Present such and such, Monday, dated such and such. Now kindly mark the second one. CNR number WBNP 1000-20254 of 2024. Criminal appeal number 04 of 2024. So it is apparent from the record that the matter has been numbered as criminal appeal by the judicial additional district and session judge. Up to this, Lordship is clear. এটা এইদিকে যাব না এইদিকে যাব, নিচে যাব। Now see, on the next part, judgment. which starts from 166. Justice is rooted in confidence, and justice is the goal of the quasi-judicial proceeding also. If the functioning of a quasi-judicial authority has to inspire the confidence in the minds of those subjective in the jurisdiction, such authority must such almost fairness. Its fairness is observatory to the manifest. Now kindly come to the prologue. The appeal under Section 6C of the Essential Commodity Act has been preferred by the applicant aggrieved by the order of confiscation, seized essential commodity passed by the learned subdivisional officer Boshirar such and such in case number such and such. দুটো দেখি না এইটুকুনি দেখুন। Now kindly come to the understanding of the court, Millard. This is confiscation proceedings of such and such empty lies and the reported quantity metric ton of the wheat, out of which 232 metric ton was sought to be exported by the present.
Let him be refrain from reading the judgment. My lord, it's not. Let him make out his preliminary objections.
Yes.
So he should not read. That is the prerogative of the petitioner. Well, I'll read it in my own way.
Okay.
Let him take the point of maintainability.
I don't understand why Mr. Bandyopadhyay.
I am aggrieved. Because this is the carriage of proceedings with me.
Yes, of course.
2023, he didn't.
If somebody is trying, no, definitely not. I have.
Mr. Bandyopadhyay wanted to argue what is your point of maintainability. That is the
Millet, if I don't give the Millet the background of the same,
Yes, I
why?
understand.
Otherwise,
Background I'll give.
No.
Very well.
No, Mr. Senutto, what you want to argue? No, what is the point?
Point Lordship has seen, this is a matter of the criminal proceedings has come up. Right? Now,
Not criminal proceeding. Confiscation proceeding is passed by the SDO. Thereafter, the appellate provision. This is the total civil proceeding, not criminal proceeding.
this is not a criminal proceeding.
No, not a criminal.
Very well. Lordship's is understanding of
Yes,
that.
I know that.
Very well.
So, what
Then-
is your point here?
Now, then I am asking myself, kindly come back to the first page.
Yes.
First page. Lordship has seized, the number has been, number as CNR number WBNP, criminal appeal number 242021. So if it is the administrative order, in that event, the criminal appeal number could not have been pointed out over here. It's a criminal appeal. It's an absolutely technical appeal. It is not a question of the administrative order passed by the such and such. Administrative order could have been passed by the collector, then come the SDO, then the appeal comes before the appropriate authority. That is the the additional district and session judge, first strike Barasat.
Yes.
Had it been a case, this is a administrative order. Administrative order cannot be renumbered or numbered as a criminal appeal number 04 of 2024. This cannot be. Now come to the
Now, what is your point? In the read jurisdiction, the judicial order cannot challenge.
no.
That is your point.
That's a point. First of all, yes, Lordship kindly bearing in the mind, which I have pointed out in the first instance, 6C appeal. The 6C appeal speaks about the appeal to the judicial authority,
Yes.
not the quasi-judicial authority.
Yes.
Judicial authority means, Lordship knows far better than I do. Lordship is coming from that angle. The judicial authority are the judicial officers who have the authority to take the matters in the capacity of a judicial authority.
Under judicial functioning.
Under judicial functioning. Kindly, I also desist. Had it been a case, this could have been clearly speaks about the appeal, then I have nothing to say. When the statute had unambiguously stated something that look here, this has to be tried and before the judicial authority, this has to be done before the judicial authority, and judicial authority is the the authority who can try. Is the authority who can try out this appeal. So the first appeal of the collector, SDO, everything is gone. Now the first stage we are on. Now the second things.
Yes.
Whether sitting on, forget for a moment, Millard. This is a Millard. First instance, Lordships kindly think for a moment. Lordship is sitting on a 226 jurisdictions.
Yes.
It's a high prerogative writ.
Yes.
Question is that sitting on the high prerogative writ, the court can interfere in the judicial proceedings, mainly the prayer made out in the petition, that look here, this part of the judgment is not viable to me, is not favorable to me, therefore you quash this same or you modify the same. I am asking myself, sitting on a high prerogative jurisdiction, can the writ court do so? Can the writ court do so? In my humble understanding, it is not. Once the matter is being renumbered and numbered as a criminal in nature, this has to go before the criminal bench, criminal determination, not before the 226.
No, you were clear that this is the criminal proceeding.
This is a.
Are you arguing on that point?
Yes, Millard had it.
This is not a criminal confiscation. Is not a criminal proceeding.
Millard, this is confiscation is
power.
Correct. Lordship is correct.
But the power of confiscation is not a criminal proceeding.
Millard, this is not the question of the questioning of the power of confiscation. It is not the question of power of
order of
confiscation has been done. 6A and B has been over. Then it is coming to the point of appeal.
Yes, 6C.
6C. Once the 6C.
Submission is that the order passed by a judicial authority cannot come under challenge under 226.
That if it is numbered as a criminal proceedings, that cannot be done. I will show to your lordship the judgments. Huh?
So this is your point. Very of
course. Now, ঠিক আছে পরে দেখা তুই আমাকে ইয়েটা দে আগে রাধের সামনে না ইন্দ্রাণী চক্রবর্তী রাধের সামনে Now, Millard, this question,
yes,
before the 2015, this was the point of controversy.
Yes.
Whether 226 or 227 is having the at par or not. There is a judgment of Surya Devi Rai. Surya Devi Rai says, yes, in a judicial proceedings, any judicial order can be altered by the 226 court. Surya Devi Rai says so. Very, very honestly speaking. Now, Millard, in 2015, 5 judges bench says no, this cannot be done. 3 judges bench. This is Radhesham versus Millard Chabinak. Lordship, kindly have a look into that. 2015 5 Supreme Court SCC 423. 423. টাকে আগে দেখাই আগে 425 টাকে না আমি এখান থেকে দেখাতে চাইছি অ্যাসেন্ডিং টু দ্য ইন্টারিম অর্ডার ২২ তো আগে একটুখানি দেখি দেখি কি শুরু হচ্ছে নামটা কি রাধেশ্যাম ভার্সেস ছাবি
Yes.
ছাবি না Now, kindly come to the second page of the same. Prior to that, Lordship has seized, the distinction has been made in the head notes 226 and 227. There is a scope, determination,
Yes.
jurisdiction, everything. I am not traveling your Lordship to the same. Now, kindly come to the second part. Constitution of India. Have your Lordship got it? On the second page itself. Article 226, 227 and 32. Technicalities associated with the progressive writs in the England have no role to play under the Indian constitutional scheme. Assessing in the interim order of the civil court in a pending suit, the respondent defendant filed a writ petition before the Allahabad High Court. The High Court, having vacated the said interim order, granted in favor of the applicant plaintiff. The applicant moved the Supreme Court by way of a special leave petition inter alia, contending that the writ petition under Article 226 was not maintainable against the order of the civil court, and thus the impugned order could not be passed by the High Court. The respondent placed reliance on the two judges bench of the Supreme Court in Surya Devi Rai 2003 675, which laid down that a writ petition under 226 was maintainable against the order of the civil court, and submitted that the High Court was justified passing the impugned order. But another two bench which heard the matter was not perused to follow the law laid down in the Surya Devi Rai. It was observed that the judgment in the Surya Devi Rai case did not correctly appreciated the ratio laid down in the earlier 9 judges bench in the Supreme Court in the Noresh Sridhalkar Midhalkar in AIR 1967 SC1, wherein the Supreme Court came to conclusion that the certiorari does not lie to coerce the judgment, interfere courts of the civil jurisdiction, para 62. Accordingly, the matter was placed before the present 3 judges bench of the Supreme Court. Now come to the Miller. Get up. Penalty. Paragraph 24. Yeah. 24, 25. 447, তাই তো? এখান থেকে দেখি একটুখানি রাখো। হ্যাঁ দাঁড়া দেখাচ্ছি। ওই 24. Now kindly come to page 447. 24. 24-25 action. Have your Lordship got it, Milan? Page 447.
Yes. Paragraph 24.
24-5 I will be reading together. It is above holding, correctness of which was doubted in the referring of the order already mentioned above. It is true that this court has laid down the technicalities associated with the progressive writ in the inland have no prerogative rule in the inland, have no role to play under our constitutional scheme. There is no parallel system of the King's Court in India, and of all the other courts having the limited jurisdiction subject to the supervision of the King's Court. Courts are set out under the constitution of the law. All the courts of the jurisdiction of a high court are subordinate to it and subject to the control and supervision under Article 227. The writ jurisdiction is continuously conferred conferred in all the high courts broad principle of the writ jurisdiction followed by the inland are applicable to India, and a writ of certiorari lies against the patent erroneous or without jurisdiction order of the tribunals or authorities or courts other than the judicial courts. There are no precedent in India for the high courts to issue writ to the subordinate court. Millet, kindly mark that. There is no there is no substance, there is no example. Wait a minute. Court, read to subordinate court. Control of working of the subordinate court in dealing with their judicial order is exercised by your appellate or revisional power or power of subordinates under Article 227. Order of the civil court stand on the different footings from the order of the authorities or tribunals or court other than the judicial civil orders. Why appellate or the revisional jurisdiction in regulated by the statute, power or the superintendent under Article 227 is constitutional. The expression inferior court is not referable to the judicial courts as rightly observed in the referring order number such and such in para 26 and 26 above. Now kindly come to para 27. Millet, I just pointed out prior to going over there, the para 26 is basically dealt with the erroneous observation of the Suryadev Rai. I don't think, Millet, this has been overruled. So I don't require Millet to read this judgment. Now kindly come to the same paragraph 27. Thus, we are on the view that the judicial order of the civil courts are not amenable to the writ of the certiorari under Article 226. We are also in the agreement with the view of the referring bench that a writ of mandamus does not lie against a private person not discharging any public duty. Scope of the Article 227 is different from the Article 226. Now kindly come answer the question as follows. Now this is the Millet, the answer has been given. 29(1)(a). Judicial order of the civil court are not amenable to the writ jurisdiction under Article 226 of the Constitution. Jurisdiction under Article 227 is distinct from the jurisdiction under Article 226. Contrary view in the Suryadev Rai is overruled. The matter may now be listed before the appropriate bench for the further orders. Millet, so far, my contention is concerned that has been possibly answered in 29.1(a). This is the judicial order because statute has specifically stated this is the judicial order. Kindly have a look into the 6C. Sorry. 6C. 6A and B, that part is clear. Confiscations, other things has been clear. Now we are on the stage of the appeal. To whom appeal would be preferred?
Judicial authority.
Judicial order. Now, this has been stated that an appeal to any judicial authority appointed by the state government.
I understand.
Connecting these two together, it is a judicial appeal, judicial order. This, in the light of the judgment, Radhesham versus Chabinath, this writ petition is not maintainable. Let me clear the clouds more from the Indrani Chakraborty's judgment. Oh, wait. Well, Lordship, kindly take trouble to see Indrani Chakraborty of our High Court's judgment.
15 1 CHN code.
2014
15 1 CHN.
15 1 CHN.
2015
Act.
Yes. Paragraph.
প্যারা 10টাকে দেখো ওই যেখানে নাম্বারটা করা থাকে। হ্যাঁ দীপঙ্কর দেখো টিউশন নেই সিঙ্গেল তুমি ছিল বোধহয় তুমি আর তুমি ছিল এটা তো আরো ভালো রে wait. Now, from the para 3 in millet, it has been laid down. However, if a writ petition is filed alleging the investigation officer has been reminds the discharge of the statutory duty to investigation not for such and such, obviously it would open to the applying to the law laid down to the Supreme Court to the effect to the writ remedy shall not be available except where violation of some statutory duty of the part of the statutory authority is called. There is no reason why a case resembling to the cited example, the police authority may not be directed to perform statutory duty. Para 10. Now the second one. Article 226 and 227 read challenging discharge of the criminal.
You are reading paragraph?
First, I have indicated paragraph 10.
10.
Now I am on the head notes B. ওই না ওই যেখানটাতে নাম্বারিংটা হয়ে যাওয়ার পরে করা যায় ক্রিমিনাল নাম্বারিং না বলছি অরিজিৎ ওইদিকে অসুবিধা হলে এদিকে এসে পড়তে পারিস মামলাটা খুব অসুবিধা হলে
Yes, you are reading paragraph?
Yes. Good. For the reason of the declining relief under Article 226 would be that a writ petition would not lie against a judicial order passed by the judge, magistrate, exercising judicial function. The position may altogether be different if, despite pendency of a writ petition challenging an investigation of a complaint disclosing cognizable offence by the state investigation agency as tragedy and impact with a view to favor the accused, the playing for the transfer in the investigation to some other neutral agency, a police report, a file to the such and such completion of the investigation and revive the stamp of the approval of the magistrate. The writ court having been approached before the filing of the police court would be entirely within the discretion of such court whether to allow or not to allow matter to progress thereof. That is how not the case here. On the fact circumstances the present case such as such, it is not required. Kindly for a moment visualize the effect of the order passed by the judicial magistrate. What is the effect? Effect is the penal offense.
Yes.
If it has been penal offense, in that event, it is not coming under the quasi-judicial authority. It is strictly between the judicial authority, judicial magistrate. So by this observation of this court, it is abundantly clear that the judicial magistrate's order cannot be challenged in the writ court. There are other things I would like to point it out. Now, issues has been framed. The two preliminary related issues that arise from a decision here, whether a writ petition that are directed against an order passed by a judicial magistrate in the exercise of the judicial function would be maintainable. Number one, whether in view of the remedies available to the petition under the provision of the Code of Criminal Procedure, herein after CRPC, the writ petition should at all entertained. Well, these two issue has been answered herein. Now let us see, Millard, what is the answer given over here.
So your argument is that the read under Article 226 of Constitution of India is not maintainable.
Not maintainable when the order has
was
been
passed in the judicial order.
judicial manner.
227 read may be applicable.
227 is the supervision authority. This can be, but that is also some haziness.
That is
Anyway,
other issue.
but that apart, what is the major relief or the major things is available? That is the criminal proceedings. He can. Nobody.
Whatever may be the criminal proceeding or civil proceeding, you are saying the order of judicial authority cannot challenge under 220.
Under 220.
This is your main contention.
Main contention.
Very good.
This is number one. But in this order also, I just trying to finding out, there is a clear provision that once why I have pointed out in the very beginning that kindly note the number of the cases. It has been pointed out categorically that once the matter has been pointed out in the criminal number and being entertained by a magistrate or judicial capacity, read could have no jurisdiction.
No, that is not the issue. Issue is the judicial authority has passed an order, whether that is gone under the 226 or 227 or otherwise.
Exactly so. Exactly so.
This is only the point.
Only point.
Whatever may be the judicial magistrate or the civil court or civil judge like that.
Correct.
That is not the issue to
Correct.
All are the judicial officer, all are the judicial authority.
Correct. Because once the numbering has been done, or civil or the criminal, there are two different the parameters are there. One is the civil parameters, one is the criminal parameters. Read court is something different. Read court cannot step into this the jurisdiction of the criminal court or in the civil court.
Okay, I understand. This issue? Only this matter?
Only this.
Okay. Yes.
In course of my argument, my lord, I will answer his preliminary point also.
Now you just argue on that point first.
Yes. On this issue?
Yes.
Oh, just a moment. Just a moment. Just a moment, Millard. I just missed one just. Para 9 or not. It's para 9 or 8 to na. And tell it amar kora ache okan. The hand up.
What is this?
Millard, this is 2002 7 SCC.
Hansali Devi.
Hansali Devi is one of T.T. Anthony, paragraph 9. 280. Lordship has got it.
2002
7 SCC, paragraph 9, page 280. পড়ছি আমি হ্যাঁ 273 থেকে May I, Millard?
Paragraph 9. Yes.
Before we embark upon an inquiry as to what and would be the correct interpretation of the section such and such, we think is appropriate to bear in the mind certain basic principle on the interpretation of a statute. The rule stated in the Tyndall CJ in the Sussex versus such and such still holds the field. The aforesaid rule is to be effect that if the word of the statute are in themselves precise and unambiguous, then no more can be necessary than to expound this word in the neutral and the ordinary sense. The order himself alone to do in such case but declare intention of the lawgiver.
It is a cordial principle of the construction of the statute. When the language of the statute of a plain unambiguous, then the court must give effect to the words used to the statute, and you would not open to the court to adopt a hypothetical construction on the ground of such construction is more consistent with the alleged object and policy of the Act. In Krishna versus John Hudson in Company Limited,
That is in respect of interpretation of statute.
interpretation of the statute 6C, judicial.
No one denying that the judicial authority has to pass an appeal, order of appeal.
Correct. So why I am showing this in order to clarify my position that once the statute has been unambiguously stated something, no court, nobody can change the meanings or can alter the same.
No one is there. It is
Yes.
clear. It is admitted.
Yes, evident from the
6C is the judicial authority.
judicial order.
No one is there.
Correct.
Not the administrative authority like that.
Correct, my lord.
That is not required.
Because 6A and B we have already crossed. We are on the 6C.
Yes. That's all?
That's all.
Yes, Mr. Bandhavati. Yes, Mr. Bandhavati.
The subject matter relates to seizure of 181 trucks loaded with wheat. Those wheat were meant for export. They were standing at Khojadanga border. The shipping bills were given to the customs authorities. It was being processed. At that time, one jealous customs officer noted that the certain bags of the wheat contains marks of Government of Haryana, Food and Supply Department, FCI, these other, and Government of Bihar. These marks are evident. Now he said, he directed for detentions of all the trucks. Then he forwarded a report to the local police station, that is the officer in charge, Bosiraj police station, alleging that she thinks that those wheat may be the wheat of PDS wheat attempted to be diverted. You kindly investigate. Now, after this report was given, the police authority just take that report as a sacrosanct documents. They registered an FIR on the basis of that report and seized only 4 gunny bags of wheat. Out of 181, it contains 5,000 gunny bags in total. And they also seized the trucks, which are now ultimately, after that, immediately after the seizure, they submitted a prayer before the magistrate for adding. Initially, it was seized under 379, 420. These provisions were marked. Now, subsequently, they submitted a prayer before the magistrate saying that you please add Section 71AII of the Essential Commodities Act, and also before the magistrate having jurisdictions, they asked that a direction be issued to confiscate.
Yes.
The magistrate added 71AII, gave the Jimma to the flour mills of their own choice, and then entire wheat. No further seizure list was ever given, and even she directed the SDO to confiscate. The SDO, after 5-6 days, SDO straight away confiscate. Your lordship is aware the collector is the competent authority, and with the delegations of the collector in writing, anybody subordinate to SDO up to SDO can confiscate. Now, SDO, without considering this, straight away confiscate without issuing notice, nothing. A writ petition was filed before the High Court challenging the seizure as well as this process. No interim order was passed, and directions for affidavits were given. Now, that was appealed against by the present petitioners. There are others also. Now, the division bench found that the entire exercise was without jurisdiction because the confiscation cannot be done. One should follow the procedure prescribed under 6B, 6 and 6A.
A, B, and there
C. C comes later. So the division bench straightway caused that purported confiscations and directed the concerned authority that you initiate process of trace confiscation proceedings after following the provisions under Section 6B and 6A.
Okay.
Now, After this order, my lord, the SDO again issued a notice. My lord, purported, my lord, he referred it to be the so-called notice as per section 6B. That was replied against. Preliminary of submissions was made that you please give us the seizure list of entire 181 trucks, only 4 bags. Nothing. You take inspections of the goods where those were lying, because those were unloaded and given to the flour mills. And the trucks, my lord, those were a separate proceedings was also initiated for. I don't know whether this separate proceeding is permissible under the provision. Now, ultimately, SDO mechanically, my lord, issued the confiscation order again, but without furnishing the seizure list and other documents. But he released all the trucks. Well, under law, under section 6A, I'll show that when goods are being confiscated, he could only release the trucks in lieu of fine equal to the price of the truck. That he simply released the truck because the truck owners have agitated, so he released those trucks. Our goods were confiscated.
That's an answer to the maintainability point.
Our goods were confiscated.
So there is no answer even. There is no answer even.
Our goods were confiscated.
There is no answer.
But against that, but I'm much senior. In fact, I was friend to his chamber senior. So it is not expected that he should poke me, my lord. I know that what to give answers, my lord. That
This
I've
is
been
very
practicing
unheard
for
of.
30
I have
I
taken
am
things very
taking his
sportingly. I have taken it
This
very
is not
sportingly.
You just sit tight. Let him argue. I'm
No,
hearing.
I'm not.
What is
I'm not.
fallen from your lordship, that is that
Why
the
are you
maintainability
single
point
case?
would be argued.
This is
No, no.
absurd.
In that event, he is arguing the point of the merits of the case.
Yes, I'm
I've
hearing
not
out.
touched
I
any
shall
page.
hear it out.
I have not shown any page.
Yes.
I'm just narrating the events.
Now today, in the second half, there is.
And I don't want to learn from my junior friend.
Yes,
my lord.
yes, very
That
Certainly
thing
not.
I'm-
Certainly not.
My age I
Certainly
have
not.
crossed.
Certainly not.
Okay.
Certainly not.
Mr. Sengupta, just wait. So when can it be done? Today? Today, let's continue.
My lord, and the
2
second
PM?
half, I don't know whether any matter is fixed or not.
2 PM কোনো fix আছে?
সেকেন্ড তো আজকাল কেন করবে স্বাগতদা?
2 PM কোনো fix আছে? কি fix আছে?
তুমি করবো আমরা করবে?
হ্যাঁ, পাঠাও না এটা।
দেবুদার না, এটাই হচ্ছে সবচেয়ে ব্যাপার।
হ্যাঁ?
হুট করে রেগে যায়, করে যায়, কেন কেন?
আজকে কি বার 5
তোমার মামলা একটা দুটো
হবে 7 তারিখে হবে না।
দেখি 2 PM কি আছে? অনেকগুলো আছে, পরপর আছে। না, এটা শেষ করো। Let it be continued.
Let it be continued.
Let it be
I'm
continued.
coming back, my lord, after.
Yes, at 2 PM.
At 2.
কন্টিনিউ।
Shana, the matter is fixed today, item number 13 at 2 p.m. KMDA's lawyer's mother has passed away. So I am appearing on behalf of the petitioner. Since I know about it, since my learned friend would not be here, I'm only humbly praying if my lord would adjourn the matter and refix after 2 weeks so that the matter could be taken up.
2 weeks means after vacation.
Whatever my lord's
Okay.
direction, I would rather, without his assistance.
I understand. I understand. Please take down item number 13. Item number 13. Let the matter appear in the list on 11th of June.
My lord, at 2 p.m.
Then it would be 13th of June at 2 p.m. 13th of June, Friday. 13th of June, Shukra, okay. Okay, 12th of June, 11th June, 12th of June. 12th of June at 12:30. 12th of June at 12:30. Okay.
I'm grateful.
Thank you. Yes, Mr. Bandyopadhyay.
Mr. Pradeep Sanjitla.
Yes, my lord, I had told you, lordships, my lord, there is a division bench, my lord, when the matter was moved before this honorable court, my lord, after hearing all issues, the division bench set aside the order of confiscation initially passed and directed the authority, my lord, to proceed afresh. I just want to in regard to the maintainability issue, one page of the division bench judgment, my lord, kindly take page 92. 96 that's it. In your lordship's brief, my lord, it should be 96. My lord, I was holding the brief of item number 2. Since Mr. Sengupta had pointed out from 9. Item number paragraph 18. Has the lordship got it? Paragraph 18 of that judgment. 105. 105, your lordship, kindly come.
MAT 756.
Yes, yes.
Well, may I take a short leave?
MAT 756.
हमने असेंट लीडটা করেছিলাম 8 or 9
I got it.
Because it will not tally with my page numbers.
Very well. Not necessary. You mentioned the paragraph.
Yes, paragraph 18, my lord. Has the lordship got it?
Paragraph 18, yes.
May I just read? If any person contravenes any order made under section 3, the investigating agency may prosecute him under section 7 of the EC Act before the competent criminal court, and the property. না আমি এখান থেকেই পড়ছি 18. হ্যাঁ, if any person appellate order, division bench. My lord, I'm sorry, my lord. It's the division bench order. Has you also got it?
Yes.
Paragraph 18?
Yes.
ঠিকই তো বলছি আমি 91 probably in your lordship.
Yes,
brief.
in my brief 91.
91. If any person contravenes any order made under section 3, the investigating agency may prosecute him under section 7 of the EC Act before the competent criminal court, and the property in respect of which the order has been contravened may be forfeited to the government by the order of the said code in terms of subsection 1 of section 7. Then, my lord, subsection 1 of section 6A.
Yes.
Requires an investigation agency to report to the collector without any unreasonable delay as to a seizure made under the EC Act. And upon such report being made, the concerned collector may initiate confiscation proceedings if he is satisfied as to the violation of the order passed under Section 3 of the EC Act. An order of forfeiture is a judicial order passed by a competent criminal court upon proving a guilt, while confiscation, I'm just stressing, while confiscation is an administrative action to be undertaken by the collector. Both the proceedings may run simultaneously. It was therefore wholly unnecessary for the investigation agency to approach the learned magistrate for confiscation of the goods at the investigation stage, and it was equally inapposite for the learned magistrate to direct the state to confiscate the goods. Why I had shown you, lordships, one of the confiscation proceedings is a purely administrative proceedings. It is held by the division bench, it is unassailed, but it remains. Now, against this, my lord, an appeal is to be preferred. The wording of the statute says it's the judicial authority. Now, in case of, my lord, various other proceedings, I'm just giving that example, the judges of this honorable court, they have got twofold power. One is judicial functions to be discharged in court. Another is, my lord, there is a certain supervisory functions, my lord, over the and the disciplinary proceedings and other aspects which are administrative functions. And if it is disciplinary proceedings, it is a quasi-judicial function. But it has been consistently held that the confiscation proceedings is akin to the disciplinary proceedings. It's a quasi-judicial function. Now, even in case of district, I have dealt with a matter where the court officers of the lower judiciary was involved. There were allegations of certain allegations. Disciplinary proceedings, competent authority is the district judge. So, in dealing with these disciplinary proceedings, the district judge, though being a judicial authority, discharges administrative and quasi-judicial functions, not the judicial function. Am I clear to your lordship?
Yes, I know that.
It's not a judicial. The mere mentioning of the judicial authority.
No, the question here is that the order under Section 6C.
Yes,
whether amenable under 226 or 227.
That is why I
that is the question.
Because the 2015 judgment, which my learned friend is relying on, is an order purely arising out of civil proceeding, under Order 30 and Rule 1 and 2, that was challenged. Well, in that case, the court was discharging a judicial functions. Now here, only he tried to show that 6C mentions judicial authority. So it's a judicial function. It is not like that. It can be an administrative or can be a quasi-judicial function. Now, I had shown from the division bench judgment that the confiscation proceeding, it need not be shown, it is the law. The confiscation proceedings are administrative functions akin to the quasi-judicial functions. Now, an order of confiscation is passed that was appealable where? Before the additional district judge. That was the judicial authority named in the provisions. Very recently, the Andhra Pradesh High Court dealt with the same issue. That what will be the actual proceeding? Whether it will be 227, you also is aware that it can be assailed before the 227 court. Yes. It can be 227 criminal or 227 civil.
Yes.
It's not a criminal discharge, it's a 227 or it is 226. Now the Andhra Pradesh High Court relying on the earlier judgment because they are now in West Bengal, I have not seen any confiscation proceedings in the last 10-20 years. Earlier there were confiscation proceedings. একটাই judgment আছে আর কপি and both 226 and 227 are constitutional courts. Now the first I will be relying on, I will be giving them a copy. It's straight away downloaded from the court's website. It's writ petition number 29791 of 2024. কি কপি দিতে হবে ওদের নেই কপি একটা দিয়ে দে না আমার কাছে আরেকটা আছে মে আই রিড মালা হ্যাঁ দিচ্ছি This writ petition under Article 226 of the Constitution is filed for the following relief. To issue order directions, one in the nature of writ of maneuver declaring the actions of the second respondent and issuing the impugned order dated 1st April 2023, ordering to confiscate the seized stocks of rice such and such bearing number, release the same vehicle instead of not accepting third-party signature such and such, consequently to direct the respondent to release. The case of the petitioner is briefly as follows. The petitioner is the owner of the vehicle number such and such. It was seized on the allegation that the PDS rice was being carried in that vehicle. The petitioner preferred criminal appeal number before the Court of Sessions Judge Kurnool, in which criminal MP was filed under Section 6C2 of the Essential Commodities Act to direct the Tricildar. Again, in that case also, the criminal number has been given. To direct the Tahsildar, Benganapalli Mandal, to release the seized vehicle in interim custody pending the disposal of the appeal which was filed against the orders of. After hearing both parties, the Session Judge Kurnool allowed the petition and ordered release of the vehicles towards interim custody upon furnishing a bank guarantee to the satisfaction of the court, with an undertaking that the petitioner would not alter or alienate the vehicle till finalization of the appeal, and further undertakes that he would not by himself through orders use the vehicle or any illegal purpose. And in the very repetitions, I am just skipping. This is the quote. Initially, next page, page 3, paragraph 4. Initially, the learned assistant government pleader objected the maintainability of the writ petition under 226 of the Constitution of India against the order passed by the Sessions Court. Now, this court, the Honorable High Court, relies on the earlier judgment of the same court. The learned counsel for the petitioner placed reliance on the decisions of this High Court in V. Venugopal and another versus Joint Collector Chittoor District, where it was held as follows. The weighty judicial authority leads to irresistible conclusion that even where the special statute read with the provisions provide for a remedy of a division against the inferior criminal court acting either as judicial authority or personal designator, a petitioner for writ of certiorari is not absolutely barred. If a legislative enactment provides for an appellate remedy and attaches finality, certainly the writ jurisdiction is not barred even if there is no certiorari clause, but special enactment does not attach finality to the appellate order. A revision to the High Court either under the special enactment or under 220 Constitution is maintainable. This itself does not exclude the prerogative jurisdiction under Article 226 of the Constitution. As it was originally enacted, Essential Commodities Act provides for an appeal to the judicial authority designated by the state government. These provisions was, however, eclipsed by reasons of the amendment in 1981 for a period of 15 years. This was a special provisions period. During this period, a revision was barred and necessarily certiorari jurisdiction of the High Court was available against the appellate order passed by the state government under Section 6C of the Act. After eclipse is removed, Section 6C of the Act as it originally existed is revised. In this background, assumption of jurisdictions cannot be doubted under Article 226 of the Constitution of India, even though remedy of revision under 226 is ineffective. This court may now run to the merits of the case. All right, I have also Venugopal. I have got this judgment 2010 SCC online 356. Not page 9. No. Yes. This is as quoted. I have just quoted portions. You will also get it. Page 8. Page 8. Page 8, third paragraph onward. Fourth paragraph on the weighty judicial authority list. That was quoted. Up to next page, second paragraph. Next page, second paragraph. This has been quoted and this has been relied on. Now, in any event, my lord, probably now those days are over when whether it is 226 or 227 can be considered and can be questioned. And in dealing this technicality can be taken. This was earlier the good ground of challenge that raised this question issue at the stage of. Now the Supreme Court had also come heavy that the court cannot go by these technicalities, whether it will be 227 or 226. But on this issue, I will be relying on a very recent Supreme Court judgment. It is also 3 judges bench decisions, reported at 2021 15 SCC. Kiran Dev. 2021 15 SCC, page 15. Thank you. 2021 15 SCC, page 15. Now kindly take, my lord, paragraphs 22 onwards. These arise, my lord, from the orders passed by the Waqf Tribunal.
Yes.
Now kindly take what the Supreme Court has said and what the objection taken. This is also a 3 judges bench judgment. 2015 was also a thing. That was a special case purely arising out of a civil court's order under temporary injunctions. That was absolutely. But here, this is not a purely a civil court's order. This is under the special statute, under 6C. In fact, it was earlier treated, this district, additional district was treated as a personal designator.
Yes.
In earlier. And only, my lord, that difficulty is he has, in each case, the government had to name him. That this person, this judge would be the, then if this is named, then
notification in name.
Name. If it is named, then he becomes the personal designator.
Yes.
No question of discharging judicial function. Kindly take paragraph 22. Or my learned junior says, my lord, I read from paragraph 20 onwards. Origin. Married.
Yes.
It will be at page 11 of that judgment.
Yes.
25 also. Page 11, the SCC citation. A perusal of the proviso, perusal to the proviso of, oh, page running. At 25 was the running page, 11 of the A perusal of the proviso to the subsection 9 of section 83 of the Act shows that it confers power on the High Court to call for and examine the records relating to any dispute, question, or other matter which has been determined by the tribunal for the purpose of satisfying itself as to the correctness, legality, propriety. In fact, the statutory provisions is acceptance of the principle that jurisdiction the High Court under 226 or 226 Constitution of India cannot be curtailed in terms of the L. Chandrakumar and Union of India. Malad, this is 5 judges bench judgment. L. Chandrakumar and Union of India. Malad, the question is, Malad, under the Essential Commodities Act, there is no provisions that the jurisdiction of 226 court is curtailed. Here also, Malad, the same provisions was there. There is no curtailment of the power. It cannot be curtailed. Then that will be a good ground for declaring that provisions are valid. Malad, we may first address the issue of exclusion of the power of judicial review of the High Courts. We have already held that in respect of the power of judicial review, the jurisdiction of the High Courts under Article 226 or 227 cannot wholly be excluded. On the other hand, to hold that all such decisions will be subject to the jurisdiction of the High Courts under Article Constitution before a division bench of the High Court within whose territorial jurisdiction the tribunal concerned falls will serve two purposes. While having the power of judicial review of legislative function vested in the High Courts under Article 226 and 227 of the Constitution, it will ensure that the frivolous claims are filtered out through the process of adjudication in the tribunal. The High Court will also have the benefit of a reasoned decision on merits. We have already emphasized the necessity for ensuring that the High Courts are able to exercise judicial superintendence over the decisions of the tribunals under Article 227 of the Constitution. In R.K. Jain's case, after taking note of this fact, it was suggested that the possibility of an appeal from the tribunal on the question of law to the division bench of a High Court within whose territorial jurisdiction the tribunal falls be pursued. It appears that no follow-up actions have been taken to the suggestion. Such a measure would have improved the matter considerably, having regard to both the aforesaid contentions. We hold that all decisions of the tribunals, whether created pursuant to Article 323A or 323B of the Constitution, will be subject to the High Court's writ jurisdiction under articles both 226 or 227 of the Constitution before a division bench of the High Court within whose territorial jurisdiction particular tribunal falls. But I'm pausing here for a moment that because the division bench Supreme Court order, because other than the starter high courts, in all high courts, mostly all high courts, the writ is filed before the division bench.
Yes.
And there was no mandamus appeal because there no letters patent, no mandamus appeal. Clause 15 was not there. A three-judge bench in a judgment reported in Radhesham versus Chabina, he relied on, held that the observations in para 25 of the judgment in Surya Devi and Ramchandra Rai to be not good law. In Surya Devi Rai, it was held that the order of the civil court could not be challenged in a petition article. That distinction between articles and 226 or 227 of the Constitution of India stood almost obliterated. Now this court, Radhesham, has been quoted. Therefore, when a petition is filed against an order of the work of tribunal before the High Court exercises the jurisdiction under Article 227 of the Constitution of India. Therefore, it is wholly immaterial that the petition was titled as writ petitions. It may be noticed that in certain high courts, petition under 227 is titled as writ petition. In certain other high court as revision petition. In certain others as a miscellaneous petition. However, keeping in view of the nature of the order passed, more particularly in the light of the proviso to subsection 9 of section 83, the High Court restricted to only examine the correctness, legality or propriety of the findings recorded by the work of tribunal. The High Court, in exercise of the jurisdiction conferred under the provisions, does not act as the appellate court. We find merit. I'm reading, continuously reading. The next 23. Yes, we find merit in the argument raised by Mr. Sannal that the nomenclature of the title of the petitioner filed before the High Court is immaterial. In Municipal Corporation versus Ahmedabad versus Ben Hirabin Manilal, this court held that the wrong reference to the power under which an action was taken by the government would not per se vitiate the actions, if the same would be justified under some other power whereby the government could lawfully do the act. The court held as under, I'm skipping, my lord. Next, paragraph 24. Later, this is a PepsiCo judgment, renowned judgment. Later in Pepsi Foods Limited, this court held that the nomenclature under which the petition is filed is not quite relevant and it does not divert the court from exercising a jurisdiction which otherwise it possesses. I am pausing here for a moment that this High Court, your lordship as a single judge, your lordship has the power, subject to determine and even to hear a 227 petitions. That is being dealt with by the Supreme Court in this case. If the court finds that the appellants could not invoke its jurisdiction under Article 226, the court can certainly treat the petition as one under 227 or Section 482 of the court. Now, this court held this paragraph has been quoted. Now, 25. I am not reading the quotations, these are the actuals which has been synopsised in paragraph 24.
Yes.
Therefore, the petition styled as one under 226 would not bar the High Court to exercise jurisdiction under the Act and or under 227 of the Constitution. The jurisdiction of the High Court to examine the correctness, legality and propriety of determination of a dispute by the tribunal is reserved with the High Court. The nomenclature of the proceedings at petition under 226 or 227 is wholly inconsequential and immaterial. So what? Considering the scheme of the provisions, now I will be showing the scheme of the provisions of under Essential Commodities Act. Now kindly take Essential Commodities Act. Once, if you I can have the bare act.
I have the copy. Yes.
Six. I'll start a little bit earlier from section 3.
Yes.
Because that will be touching the merits subsequently. It will help me, my lord. I may not read it again. My lord, section 3 empowers, my lord, by this legislation. The Essential Commodities is a parliamentary legislation. The parliament empowers the central government to issue certain orders or regulations. That empowerment is under section 3. Now, if you also kindly take, if the central government is of the opinion that it is necessary or expedient so to do for maintaining or increasing the supplies of any essential commodity or for securing their equitable distribution and availability at the fair price shop, or for securing the any essential commodity for the defense of India or the effect, conduct or military operation, it may by order provide for regulating, prohibiting production, supply and distribution thereof and trade and commerce therein. Pause here a moment. This is the empowerment upon the central government to by order regulate, prohibit the production and supply, distribution thereof and trade and commerce therein. So the empowerment 3.1 is the general provisions whereby the central government has been authorized to issue orders.
Yes.
So any order, all these control orders you have gone, your lordship has gone through the PDS control order. There are earlier this kerosene control order, stocks display order. Those were there. Those are the control orders issued by virtue of the power vested under section 3.1. Because this power can also be delegated upon the state government. Now the central government delegates the power upon the state government under section 5 of that. And by virtue of this delegated authority, the state government can also issue order under section 3.1. Now these are the general provisions, and this has been certain under 1A, there are various subjects that these regulations may contain this field or this can cover these fields. That there are several fields. Yes. Now these are the fields. You also is aware this distribution, public distribution, essential commodities comes under 33 of the concurrent list. Entry 33 of the concurrent list. There are other, the central government first exercise jurisdiction followed, and there was a vacuum at one point of time. Then ordinance had been first issued, then this act came forward. So now this is the occupied field. We can say that this particular entry has been occupied by the central government.
Yes.
Now, these are the special. Now, these control orders are to be placed before the, it should be first published before the official gazette, subsection 5 at page 13, and then if it is done by central government, it is to be placed before the parliament. That is subsection 6, page 13. So these are statutory control orders. As you also got it, page 13. I'm just keeping others, my lord. There are provisions of price fixation for sugar, the provisions of dealership, my lord, those are there, my lord. In the 5 is, my lord, an order made under this subsection shall, in case of an order of a general nature or affecting a class of persons, be notified in the official gazette. As you also got it, 3A.
3A.
Yes, it must be published in the official gazette. B, in the case of an order directed to a specified individual, be served on such individual by delivering or affixing. Now, subsection 6, every order made under this section by the central government or by any officer or authority of the central government shall be laid before both houses of the parliament as soon as may be after it is made. So when it is placed, it becomes virtually a legislation. Now kindly take subsection 5, section 5.
Delegation of powers.
Delegation of power. May I just read? The central government may, by notified order, that order is also to be notified. Now that notified order is issued under section 5 itself, not under section 3. The delegations is made under section 5. The notified order direct that the power to make orders or to issue notifications under section 3 shall in relations to such matters or subject to such conditions, if any, as may be specified in the director, be accessible also by such officer or authority subordinate to the central government or such state government or such officer or authority subordinate to the state government as may be specified in that direction. So there should be a delegating notification, which should be published, and in by delegating notification, state government or any officer of the state government may be delegated with the power to issue direction or order under section 3.
Yes.
May I clear, my lord?
Yes.
Now comes to, my lord, inconsistency section 6. It will have overriding effect. Any order issued under section 3 shall have an overriding effect. There was 6A confiscation of the essential commodities. Before that, I just want to show now, Your Lordship, kindly take page 3 to 3.25 of that Your Lordship's book. Colored
3.25.
Yes. This is part of kerosene control order. All control order, just it will be easy for me. Kindly take this is a part of kerosene control order, paragraph 15. Has
Yes.
you got it?
Clause
This is
15.
Paragraph 15. Clause 15. Power to enter, inspect premises and to require information accounts, seize books of accounts and other documents. This is the power of entry and seizure. This power has been vested with certain authorities. May I just read even in the kerosene controller, I will show from the PDS controller also. That certain authorities, not below the rank of sub-divisional controller, enforcement branch, they can enter any premises, they can make seizure, search. Now kindly take PDS control order also.
Now, what do you want to prove?
I'm just coming, my lord. Kindly take PDS control order. My lord, PDS control order, page 1.32, paragraph 30.
Clause 13.
30, my lord.
30.
The power to enter, inspect premises, to require information, etc., etc. My lord, last, my lord, inspect and G, inspect and seize any stock of public distribution commodity or any document relating to. The both power of search and seizure was vested under this control order.
Yes.
Now kindly read, my lord, section 6A. Where? I'll go by slow. First 3 line, I'll be very slow. Where any essential commodity has been defined under the, I need not show it. Essential commodity is seized. What? How? In pursuance of an order made under section 3 in relations thereto.
Yes.
Why I had shown kerosene control order? For regulating, my lord, stock, storage, sale and distribution of kerosene. A control order has been made under section 3 of the Essential Commodities Act. Now that gives a power of search and seizure. So kindly read again these 3 lines, very important. This is the condition precedent for initiation of any confiscation proceedings. If this is absent, entire thing is without jurisdiction. And that is in my case, I'll show. Very beginning, my lord, this is absent. It was not seized, those wheat were not detained, not seized pursuant to any control order issued under section 3. It was initially detained, only 4 bags were seized as per request of the customs officer. And only 379, 420 and other IPC provisions were mentioned. Then subsequently the 71AII added. On what basis? Because 7-1 AII, kindly come back to again, my lord, I'll 7-1, kindly come first.
No, you are coming on the merits of the matter.
No, I'm not. So this is, well, this is the very requirement of why I show you this the entire chapter 6A, 6B. These are the quasi-judicial functions, nothing to do with the judicial functions, as held also by the division bench. Now 6A gives power to the collector.
Yes.
To confiscate. Now 6B is show cause, kindly they come back to the 6C. Yeah, exuberant. Very exuberant.
Yes.
Appeal. Any persons agreed by an order of confiscation under section 6A. So confiscation, only thing is confiscation. Now what shall this appellate authority do? Within 1 month from the date of communications to him of such order, appeal to any judicial authority appointed by the state government concerned and the judicial authority. So any judicial authority appointed by the state government concerned, it doesn't designate anything. Whether it will be a civil judge junior division, or it will be a civil judge senior division, or
the district judge.
It should be designated. There are notifications issued in every case. Malad said designate. It's a designate. Judicial authority. I'm sorry, I'm just omitted. Any judicial shall, after giving an opportunity to the appellant to be heard, pass such order as it may think fit. What? Confirming, modifying, annulling the order appealed against. So confiscation can be confirmed. Confiscations can be annulled, or confiscation can be modified. Now, what after it is annulled, what will happen? If it is judicial authority, has no. Can you take 2, subsection 2, where under section 2, where an order under section 6A is modified or annulled by such judicial authority, or where in a prosecution. So there is 2 things. One is, kindly just mark it by pencil. There are 2 separate aspects. One is confiscation, another is prosecution. So that is why both are covered in section 6.2. An order in respect of which any confiscation has been made under section 6A. Now, order under section 6A is modified or annulled by such judicial authority, then comma, or. So used or where in a prosecution instituted for the contraventions of the order in respect of which an order of confiscation has been made under section 6A. Now the criminal case is for contravention, that order issued under section 3.
Yes.
That is section 7. So in case of contravention of any order issued under section 3, there are 2 possibilities. One is a criminal prosecution, that is mandate or 7-1 AII. It will be imprisonment, punishment will be imposed. And another is, if any goods or vehicle have been seized, that is to be confiscated. So the legislature itself bifurcate 2 proceedings altogether. One is administrative quasi-judicial functions of confiscation, another is a criminal prosecution. Then may I continue? Has been made under the person concerned is acquitted. So there are 2 possibilities. When it is modified or annulled by judicial authority in appeal, it is not modified or annulled. But ultimately in criminal prosecution, competent criminal court acquits such persons. In both these cases, what will be consequence? The person concerned. In either case, it is not possible for any reasons to return the essential commodity sources. Such persons shall accept as provided by subsection 3 of section 6A be paid the price thereof as if the essential commodity had been sold to the government with reasonable interest calculated from the date of seizure of the essential commodity, and such price shall be determined in such and such. That is why, my lord, you also will get that prayer in our petition that if it is not, because we know that those are been given to the flour mill, they converted it and they sold it out. So it is not possible for return, and it is a perishable commodity. Long it would be, my lord, pay. So that is why we prayed for price in the writ petition. So I had shown that 6C, 2 aspects. One is criminal case, for violation of, for committing offense under section 7(1) AII.
Yes.
Another is confiscation proceedings, which is an administrative quasi-judicial function. Now that has been appealed. The state government designated a judicial authority. A separate notifications appoint someone of a competent court, and it deals in such matter, not like a civil proceedings or criminal proceedings before a competent criminal court. And that is why against such order, both 226 and 227 can lie. And I relied on that this court has ample jurisdiction under Article 226 to hear it. Now, before I stop here, I just want to show similar 7(1). If and next page. Page 22.
Yes.
Sorry, 20(4). I'm sorry, extremely good. Penalties. If any person contravenes any order under section 3, 6A, you also have seen, if any person contravenes any order under section 3 and the goods are seized in pursuance of such order. Now here, if any person contravenes any order made on, he shall be punishable. This is the punishing provision. He shall be punishable. 1, in the case of an order made with reference to clause H or clause I of subsection 2 of that section. I just omitted to note that clause H clauses with imprisonment for a term which may extend to 1 year, and II it should extend to 7 years. For other clauses, it will extend to 7 years. This is the punishing provision. This is a criminal offense under 7(1) AII. So in both these cases, for violating any order issued under section 3, there are two things. One is confiscation proceedings, and other is criminal prosecution. Now, confiscation proceedings, suppose today, you will also have seen there are appeal provisions in various control order. Against the punishment, you should need to pass a first appellate forum, then the second appellate forum. These are the quasi-judicial proceedings, so far as the control orders are concerned. So this is confiscation proceeding is purely administrative quasi-judicial proceedings, and appellate authority also discharges the appellate authority cannot take evidence. It needs to give. There is no trial. He needs to deal with as an appellate authority, just like in a quasi-judicial proceedings. Whether the show cause notice has been issued, whether that there are charges or not, whether the petitioner was given hearing or not. These are the aspects to be considered by the appellate authority. And as rightly held by the Andhra Pradesh High Court, even in 2024, the REIT and 227 both are maintainable. We chose to file 226 because both under 226 and 227, the decision making a quasi-judicial order can be reviewed. Now here in our case, I'm not showing anything. The conditions precedents for initiation of the confiscation proceedings was lacking. Never at any stage it said that the goods were seized in pursuance of an order issued under section 3 and you have violated these provisions of a control order. Never, no had. Even before after the remand also, the show cause is silent. What provisions are, what control order are violated? No, you have not violated anything. Despite that, we want to confiscate. Now the appellate authority accepts all our arguments, saying that the basic ingredient is missing in the confiscation proceedings. He set aside, annulled the confiscation order, but again remanded back to the collector, starting from very beginning. SDU. That question, that whether it can be remanded in such a situation, when the basic thing, the jurisdictional issue was decided in our favor, this is under before your lordship, that how could it be remanded back? Already these exporters who are the petitioners, they have lost much. They have been penalized by their foreign importers also, because those all exports were against valid LC, letter of credit. The foreign buyers have penalized them. Now the goods were detained. Those were sold in 2021. 21. Today we are in, this order was passed in sometimes in 2023. It was again demanded back to correct what they should correct. There's no material available. I'll show every material. How it should be corrected. How this remand. Your Lordship is aware of the provisions under Order 41, Rule 23 and 23A that when the court can remand, if the trial court had failed to consider the evidence or some evidence has not forthcoming, these are the issues. Now, my merely holding that you have committed this wrong, nothing is there, set aside, again it is remanded back. It's delayed, but it's not only prejudicial, it's against the principle of remand. Now, on maintainability, these are my submissions. Okay. If your Lordship now invites me to argue on merit, I can continue.
Yes, Mr. Sengupta, anything argue?
Yes, certainly.
No, Mr. Sahara, okay. Mr. Sahara, you can argue on the point of maintainability.
That is why
in the point of maintainability.
Just 2 minutes.
Yes.
My learned Mr. Sengupta has relied on the judgment of Justice Deepak Dutta.
Yes.
As a frequently appear in this matter also, at paragraph 6, my submission has been recorded. That is Indrani Chakraborty.
Indrani Chakraborty.
Paragraph 6, my submission has been recorded, but I am not wrong there. Just before facing the judgment, Mr. Bandyopadhyay had elaborately argued the 2 proceedings under section 7A III criminal proceedings. So for confiscation, initiation of proceedings is an administrative job. I don't think we have to elaborate the argument after division bench order passed in the previous proceedings. That order has never been challenged. What happened? Confiscation order, division bench 8/10, quashed, set aside, matter remitted back. Again, SDO step into court, passed an order. What number has been enumerated in the judge in a case cannot be a consideration whether it is a criminal case or civil case or administrative order. It is apparent from the initiation of proceedings. If a proceedings is initiated under criminal law, if a learned judge in a appeal court gives a civil number, does it mean a civil proceedings? In the case, what happened? Remit back, order passed, appeal filed. Statute says 2 proceedings. If any offense is committed by any person, punishment is there, penal action is there under 7A.
Yes.
Other part, confiscation. Who is initiating the proceedings? SDO.
Collector.
Collector. He is not a criminal court. If any proceedings, what I want to say, if any proceedings, original authority, a statutory authority or constitutional authority, can it be changed in a criminal matter? And judgment which has been relied on by Mr. Shetgut 2015, that has distinguished by the subsequent judgment. 5 judges when Mr. Bandyopadhyay has already placed before your Lordship. But so far maintainability is concerned, I don't think there is any question should be raised. Again, I am repeating, after passing the division bench order in the previous question.
Yes.
And last initiation of question.
No, Chandra Kumar was replaced. No, that is why. 3 judges bench judgment, but they quoted 5 judges bench.
Yes, that's true. El Chandra Kumar is 5 judges.
Paragraph 3 quoted.
শোন অরিজিৎ, এই সবগুলো উত্তরটা যখন বলতে আরম্ভ করবো নিতে পারবি তো?
Yes.
It cannot be doubted that investigation by a notice of by a police officer undertaken in terms of the provisions of chapter 12 of the CRPC is an exclusive act. Although a high court cannot direct investigation conducted in a particular direction, the court most certainly can direct investigation conducted in a manner ordered by the director. As and by way of example, section 150 of the CRPC may be referred. Just pausing for a while. Is there any reference for so far our case is concerned when the matter has been remitted back? Any section of CRPC? In this case, my lord, court directed to proceed under a provision of CRPC.
Yes.
In our case, division bench directed the SDO to proceed in terms of the section 6C. 6A. So, my lord, there is a hell and hand difference so far Justice Datta's judgment is concerned and our case is concerned. My lord, these are my submissions.
Okay. Yes, in reply.
Yes. Milord, I just pointed out civil court cannot interfere in this civil and criminal matter which is running simultaneously or independently. But it was, I have never argued, in the tribunal matters which has been constituted under 323B, L. Chandra Kumar, the writ court cannot entertain. Writ court can entertain. Similarly, it's a quasi-judicial manner I will consider in that event. Similarly, in the work-off manner itself, it's a tribunal. The court have a jurisdiction. It is a quasi-judicial authority. Writ court have always entertained to that extent. But if it is purely civil or purely criminal in nature, have your lordship seen? I definitely believe lordship have seen the prayer which has been made. Kindly, kindly erase this paragraph of 101 to 108. 4. Whether that is permissible when a particular court in the scene of the matter. There is a 482. Now, I will not show any new judgment to that extent. I will only show the other judgment which I have shown to your lordship. 14 in the এটা কোথায় গেল তে না আছে তুমি বই নিয়ে এখন অশান্তি করো না, আমি পরে দিচ্ছি তোমাকে বই নিয়ে অশান্তি Now, kindly take a trouble to see.
Radhesam.
No. The
Indrani Chakraborty.
Indrani Chakraborty, correct. .15 onwards.
Yes.
Now, what does it say? 5.15. It was once again submitted that the writ of certiorari would lie only against the tribunals and authorities provided under Article 226 and not civil or criminal court, which I have just pointed out. Mr. Bandyopadhyay have cited a judgment which is related to the waqf. This is nothing but of our tribunals. In the tribunal, with my respectful submission, 226 is of course lie, but not in the exclusively manner when the civil and criminal courts are there. Now kindly come to the 5.16. The fourth submission was made that a writ of certiorari lies against the authorities and the quasi-judicial tribunals which are not coercitio senco but have trespassing civil court. In this regard, paragraph 23, 28, 29 Bharat Bank Supra were placed. At paragraph 23, the meaning of the court was discussed. At paragraph 28, a tribunal was deemed to be a civil court for certain purpose only. Now, kindly come to the 5.21. This is very important, Millard. This is the Pepsi Food Limited versus Special Judicial Magistrate. Under 227, power of the superintendence by the High Court is not only of the administrative nature, but is also judicial nature. The article confers vast power on the High Court to prevent abuse of the process of the law by interfere courts to see that the stream of the administration of the justice remain clean and pure. The power conferred on the High Court under Article 226 and 227 on the Constitution under Section 482 of the Code have no limits, but more power, more due care and cautious to be exercised while invoking these powers. When the exercising of the power could be under Article 227 or 482 Code, it may not be always be necessary to invoke the power of Article 26. So my respectful submission is that when a criminal court in the session of this matter, they are aggrieved by the same, they could have been asked for the 482 instead of the 226.
Okay.
Even a strict sense of the same, 227 can be approachable. It's a criminal matter, it can be done according to this judgment, Pepsi Food, but not 226 and not at any event. Lordship, kindly take a trouble to see the last line of the same. When the exercise of the power could be under 227 or section 482, the court may not always be necessary to invoke the provision of 226. Wait,
Yes, anything?
just a moment, Miller, kindly give me a moment. হ্যাঁ করে দেবো let kindly come to the on the same paragraph. হ্যাঁ যদি তুই জেনে যাস তাহলে আমার জায়গায় চোখে চলে আসতে হতো 7 paragraph 14 Millet, have you got Lordship got it, Millet?
Yes.
Existence of the court created under the different statute, which are not courts, stricto sensu is not unknown. The writ powers are available to exercise by a high court to the enforcement of any right conferred by the Part 3 of the Constitution to any other purpose for the enforcement of the legal right, which could be non-fundamental constitutional right or statutory right, is well known. Order passed by the courts other than the civil or the criminal could be challenged in the writ proceedings. Kindly note here, my lord. However, an order of a civil court passed in respect of the dispute between the two parties or order passed by a criminal court regarding to the complaint, investigation, search and seizure, trials, etc. in exercise of the judicial function, although might affect the right of a party, enforcement thereof cannot be asked for the taking recourses to the Article 226. If such order could be questioned in appeal or the revision by the aggrieved party in terms of the relevant general law, the Civil Procedure Code or the CRPC, the writ court ought to stay at distance and grant liberty to the party aggrieved to pursue his remedy in terms thereof and seek other constitutional remedy if available, meaning thereby High Court superintending jurisdiction under 226.
227.
227, yes. Now, paragraph 70. Assuming that Surya Devi Rai was laid down correct law, the petitioner is still not entitled to an order of the admission of the writ petition. The order of the CGM impugned in this writ petition does not suffer from an absence of the jurisdiction, although there could be challenge on the ground of the CGM in the exercise of the jurisdiction has committed an error. One might on this connection profitably refer to the decision to the committed to the error one might to the connection profitably refer to the decision of the Supreme Court in official trustee versus West Bengal versus Sachidananda Chatterjee reported on such and such. The Supreme Court was considering that what is meant by the jurisdiction and observed it could no better than quote the word of the Honorable Asutosh Mukherjee, SEG, as his lordship then was, speaking for the full bench of this court in the Hridaynath Rai versus Ramchandra Barma Sharma. The guiding principle to bear in the mind the distinction between existence of the jurisdiction and the exercise of the jurisdiction. The former relating to the assuming of the jurisdiction when there is a none, the difference between the latter where, despite being conferred with the jurisdiction, an error of the defect is committed. Milord, that apart, Lordship has seen the conclusion of this judgment. Now I would like to show your Lordship one very important Milord things. Lordship, kindly take trouble to see 6C once more. Before starting of this argument, Lordship may keep it in the mind. I have referred the Hansali Devi judgment that when a legislature making some law, there has to be, keep it in the mind, this has to be followed in toto. No court, nowhere. It can be unambiguously, if it has been given, it cannot be interpreted in any manner. Now kindly see the appeal 6.
Judicial authority, such.
Now kindly, yes. Lordship, kindly take trouble to see.
Yes.
6C. There, Lordship would find in the bracket, two things are there. The judicial authority. Have you Lordship seen that?
Yes.
Judicial authority has been substituted or rather put into the question. Initially, it was the state government. Why this has been done? Why this has been done? What is the preamble of the same? Kindly have a look into the preamble of the same. Amendment of the same. What to Joseph?
Lord, may I hand up the soft?
Amendment of amendment.
Yes.
Preamble of the
Initially, it was in the hand of the state government. Thereafter, it was gone into the hand of the judicial authority.
This was there.
The question, yes.
In the point 2 also it is mentioned in the book.
Point 2 and
50, 58.
Lordship sees in the first appeal, in the book. First, see the book first.
Yes.
1, 2, 3, third line.
There is a number 2.
Number 2. Have your Lordship got it? Any judicial authority appointed. See?
Yes.
Now see, kindly see the same. The footnotes. The word the state government concerned and the state government concerned and the state government were substituted by 5A of the Essential Commodity Special Provision as amended by this such and such Essential Commodity Act, amended, or by the word any judicial authority appointed by the state government and the judicial authority for a period of 15 years, which now cease to have been effect after the expiry of the 15 years. So pausing here for a moment. The administrative authority which was not enjoying the power, that has been substituted by the judicial authority. Now see the essential provisions of the same, object of the same. Have you Lordship got it, Miller? I just pointed out the object. An act to make certain special provision by way of amendment to the Essential Commodity Act 1955 for a temporary period of dealing more efficaciously and with the persons indulging with the holding black marketing. Kindly pause here for a moment. This is very important. And profiting in the essential commodities and with the evil vicious. Oh, sorry, এটা উঠে গেল রে বাবুই। Just a moment, উঠে গেছে। Just a moment. inefficiency prices and parties concerned thereto and incidental thereto, whereas ensuring the availability of the essential commodity of the fair price, it is necessary to curb the holdings and the black marketing and the profiting such commodities, and whereas for dealing more effectively with person indulging in such antisocial activities and the evil vicious infectionary price, it is necessary to make certain special provision by way of amendments to the Essential Commodities Act 1955 for a period of 15 years.
In connection with this, you read 5B.
Now, kindly see, Lordship has seen that what is the preamble of the same. Now see 5B. Rather, I would.
It is on the next page. It has to be like swipe. I'll
জজ সাহেবদের সবই আছে, জজ সাহেব ইউজ করে না কেন কি জানে।
Yes.
Has got it, my lord. 5B.
Yes.
Yes. Yes. In subsection B, the words are judicial authority, the word state government shall be substituted. So what is the preamble herein? To prevent the black marketing. The administrative power was there, which was enjoying by the state government. When the corruptions, fairness, arbitrariness, it has to be come into the picture, and that is the reason judicial authority has been substituted. It is not the case that the state government is citizen of the same. It is the decision of the legislature to put into the judiciary by substituting the state government. Work of tribunal can be, but not here. When the civil court when the criminal court in clear citizen of the matter. And furthermore, I would also request your lordship, kindly have a look once again to the prayer made by the petitioners, whether that is sustainable at any moment in the jurisdiction. I just, for my own satisfaction,
That is the separate merit altogether.
Merit, but this is also related to the writ petitions.
That is altogether
It is also to that extent. It is also related to the maintainability of the same. If the cause of actions is touching the same,
then I have to go to the merit of this matter.
No, it's not required.
Today you are not going to the merit of this matter.
No.
I'm dealing with your argument only on the point of matter.
To that extent, whether that is maintainable or not.
Only in the point of law. Okay.
Yes.
Very well.
May I just put that?
And the other one is Andhra Pradesh.
Just this Kiran Devi to the work of a tribunal. This is Kiran Devi, which Mr. Bandyopadhyay has shown.
Yes, Kiran Devi.
2021. This is undoubtedly the writ court have a right to interfere because it's a work of, it is coming under from the work of tribunal. Work of tribunal is separated from the civil court. It is not coming under the semicolon of the strict meanings of the court.
Single 2010 AP. This is post Sudhir Rai. This is before Radhakrishnan.
Oh, yes. No, it is the picture number 3. Oh, okay. I understand. In the last judgment, AP judgment, which this is
V. Venugopal.
State of Andhra Pradesh, Muthukuri CV. Right.
Followed V. Venugopal. Followed V. Venugopal.
Venugopal. This particular judgment is, I would say, the genesis of the Surya Devi Rai. Surya Devi Rai has been relied upon here. Wait a minute. Lordship would see the principle which has been laid down in the Surya Devi Rai, which has been referred here in the lower stage of the same. Lordship, kindly have a look into here.
Yes, this is the. Yes, I have the copy.
Yes, page 3.
Yes.
Now, Surya Devi Rai is no longer a good law which I have shown in the Radhesham and the Chabinath. This has been overruled. This entire thoughts of the Surya Devi Rai has been turned down by the Millard, the Radhesham and Chabinath in 2015. This has been 2010 online SCC AP 356. The Radhesham has come up much after the same Millard.
Yes. That's all.
But I don't think I have to show to your lordship the first point that when the lordship is taking the writ petition, I have to first argue the maintainability. If the lordship is agreeable on the maintainability point, then lordship.
I shall pass the order on maintainability. Now.
Yes. Then very well.
I will pass the order.
Very well.
What is the purpose of arguing
No,
long
that's
like
all right.
that?
I'm so sorry, madam. I'm so sorry. So I was saving this time.
No. So why I shall hear
No,
you
I'm so sorry.
all time long?
No.
Very well. Please take down.
Thank you.
Mr. Suman Sengupta, learned counsel, appearing on behalf of the state, raised the point of maintainability of these writ petitions. Full stop. On brief note, these writ petitions are preferred, challenging an order passed by learned additional district and session judge fast track first court, Basirat, North 24 Parganas, in criminal appeals, in a criminal appeal arising out of under section 6 capital C of Essential Commodities Act 1955 1955, arising out of an order of confiscation of seized essential commodity, order of confiscation of essential commodity passed by subdivisional officer Basirat. Full stop. it is the contention of Mr. Sengupta that the order was passed, impugned order was passed in a criminal appeal. Thus, the writ petition under Article 226 of Constitution of India is not maintainable. It is the further contention of Mr. Sengupta that the learned additional district and session judge first court Basirat is a judicial authority against the order of the judicial officer in a criminal appeal. Section 220, Article 227 of Constitution of India, either Article 227 of Constitution of India or Section 482 of the CRPC is maintainable. In this case, the order has been passed by a judicial officer. Against the said order, this writ court holding jurisdiction under Article 226 of Constitution cannot entertain the writ petitions. Full stop. In support of his contention, Mr. Sengupta has placed reliance upon decision of Honorable Apex Court in Radhesham and another versus Chabinath, CHHABINATH and others, reported in 2015, reported in within bracket 2015, 5 SCC 432, and Indrani Chakraborty versus State of West Bengal, within bracket 2014 SCC online 17573. I have perused the judgments. In Radhesham and another, the Honorable Apex Court has differentiated the power of High Court under Article 226 and 227 of Constitution of India. In Radhesham, an interim order of civil court is under challenge. An interim order of a civil court in a pending suit under challenge before the Allahabad High Court, wherein the High Court has vacated the interim order, against which the appellant moved the Supreme Court. Full stop. Before the Supreme Court, the respondent placed reliance upon 2 judges bench of Honorable Supreme Court in Surya Devi Rai, within bracket 2003, 6 SCC 657, which laid down that a writ petition under Article 226 is maintainable against the order of civil court. Full stop. After dealing with the matter, after dealing with the issue, the Honorable Apex Court in Radhesham has held that paragraph 25, 27 settled. তুমি দুটো বড় নিচ্ছ 25 and 27 set of code. Okay. In the case of Indrani Chakraborty, an order of Chief Judicial Magistrate concerned regarding further investigation is under challenge, wherein the honorable, where a coordinate bench of this court has held that paragraph 14, 17 set of code. Mr. Sengupta submits that the provision of section 6C, capital C of Essential Commodities Act কি বলো? Commodities Act has been amended by a special provisions under Essential Commodities within bracket Special Provisions Act 1981, whereby the term state government has been substituted by judicial authority. Full stop. He submits that when an order of appeal was passed under section 6 capital C of Essential Commodities Act by a judicial authority, a writ petition is not maintainable. A writ petition filed under section 226 of Constitution of India is not at all maintainable. He further clarified that the state government has consciously substituted judicial authority to hear out an appeal against an order of confiscation passed by collector or the state authority in section 6 capital B, thereby the reasons thereof for purpose of enactment of the special provision to curb the blackmailing of the essential commodities. Full stop. He submits that the concerned authority, being the Additional District and Session Judge First Track First Court, Basirhat, has passed the order in criminal appeal. Thus, the instant writ petition is not at all maintainable. Full stop. Mr. Sagar Bandyopadhyay, learned senior counsel, appearing on behalf of the petitioner, submits that the statute itself, that is Essential Commodities Act 1955, has enumerated section 3 regarding power of the state government to control production, supply, distribution, etc. of essential commodities. In violation of such in violation or contravention of Section 3 of Essential Commodities Act, the state government has given power under Section 5 of Essential Commodities Act to pass a notified order. Full stop. By such order, if there is a contravention of order passed under Section 3 of Essential Commodities Act, there may be there are powers of the state government to seize certain essential commodities under contravention. After seizure, there are two simultaneous proceedings. One is penal action, that is criminal proceeding under Section 7. One is the penal action enumerated under Section 7(1) within bracket Roman 7A within bracket Roman 2 of the Essential Commodities Act, that is for criminal action, and other provisions is Section 6A for confiscation of the said essential commodities. Mr. Bandyopadhyay argued that the power under Section 6A of the state government and procedures thereof regarding confiscation of essential commodities is purely an administrative order. Maybe it can be defined as quasi judicial order. Full stop. It means that the order passed under Section 6 within bracket C, capital C, of the Essential Commodities Act by the judicial authority is not an judicial order. Thus, the point raised by the learned counsel for the state authority regarding maintainability of the writ petition is not correct. It submits that the order passed under Section 6C of the Essential Commodities Act is an administrative order, though by a judicial authority. So the writ petition is maintainable. In support of his contention, Mr. Bandyopadhyay cited two decisions of Andhra Pradesh High Court, Honorable Andhra Pradesh High Court, passed in V. Venugopal and another versus Joint Collector Chittor District at Chittor, report in 2010 SCC Online AP 356, which was followed by another coordinate bench of the same High Court in Muthukuri Srinivasulu. Muthukuli Srinivasulu versus State of Andhra Pradesh. Full stop. Mr. Bandyopadhyay argued that before the Honorable Andhra Pradesh High Court, the issue was raised regarding the fact whether writ petition under Article 226 of Constitution of India is maintainable against an order under Section 6C of Essential Commodities Act, wherein the Honorable High Court at Andhra Pradesh has held that the writ petition is maintainable. He also cited a decision of Honorable Apex Court, 5 judges bench within bracket Lekho, in 2021, in Kiran Devi versus Bihar State Sunni Waqf Board and others within bracket 2021, 15 SCC, 15. He submits that the Honorable 5 judges bench of the Apex Court has held that the petition styled as one under Article 226 would not bar the High Court to exercise jurisdiction under the Act and or under Article 227 of the Constitution of India. Full stop. Mr. Bandyopadhyay emphasized that in Kiran Devi, the Honorable Apex Court has dealt with its earlier decision passed by 3 judges bench in Radhesham versus Chabinath. Full stop. In the the Mr. Devabrata Saharay, learned counsel appearing on behalf of batch of writ petitioners.
Lord, may I just one thing. Lord, probably my learned friend shown you also had quoted in section 6C, the judicial authority that was all along there. But in 81, there was a special provisions, 1981 Act. It by amendment, instead of judicial authority, it incorporated state government as the appellate authority.
For 15 years on.
For 15 years.
I
Now
understand.
that had gone now.
After 15 years, again the revive.
That is why the Honorable High Court says, during 15 years, the state government, no question.
Preamble has to be taken into care.
Okay.
I'm just
only
Mr. Saharay, learned senior counsel appearing on behalf of batch of writ petitioners, has argued that against the order of confiscation, the matter went up to Honorable Division Bench, wherein the Division Bench has set aside the order of confiscation in the first instance and directed the state government to initiate the proceeding of confiscation under Section 6A of the Essential Commodities Act. Mr. Saharay argued that the decision of Division Bench is not under challenge in appeal. So, the proceeding for confiscation initiated by the collector is an administrative order. So, the writ petition is maintainable. Full stop. In reply, Mr. Sengupta submits that before the honorable benches of Andhra Pradesh, the decision of Surya Devi Rai না কি বললাম বলো he submits that the honorable benches of Andhra Pradesh High Court has passed the decision on the basis of Surya Devi Rai, which was declared to be not a good law by Radhesham and another by Radhesham. Thus, the decision passed by the Honorable High Court of Andhra Pradesh is not applicable in this case. He further submits that in Indrani Chakraborty, the corner bench of this court has specifically guided following Pepsi Food Limited versus Special Judicial Magistrate within bracket 1998 5 SCC 749 that record. Mark portion. Yes. No.
Relator, only one judgment I have cited for your lordship, Milord, Hansali Devi Milord.
Not necessary regarding interpretation of statute.
Yes, interpretation of.
Yes, I understand. That is not necessary. দেখেছো কি ও নেবে নাকি দাও দাও নিতো নিতো আসো heard the learned counsels. Where is the order under challenge? There is no quarrel between the there is no quarrel between the learned counsels of the parties that when an order passed by an administrative authority read under section 226 and article 226 of constitution is maintainable. The dispute between the dispute regarding maintainability of the instant writ petition is that section 6C of Essential Commodities Act denoted the appellate authority to be a judicial authority stroke judicial officer. Full stop. In this particular case, learned additional district and session judge first court Basirhat has passed the impugned order. Obviously, the additional district and session judge first court Basirhat is a judicial officer who, following the jurisdiction and its power under under section 6C of the Essential Commodities Act, has passed the order in criminal appeal. Full stop. To properly understand the scheme of the statute in Essential Commodities Act, it appears that section 6A has enumerated power of confiscation of essential commodities. It has started. It has started as follows. Within inverted comma, where any essential commodity is seized in pursuance of an order made under section 3 in relation thereto, comma, a report of such seizure, comma, shall without unreasonable delay, comma, be made to the collector of the district or the presidency town in which such essential commodity is seized, full stop, no, seized, and whether or not a prosecution is instituted for the contravention of such order, comma, the collector may, comma, if he thinks it expedient to do so, comma, direct the essential commodity so seized to be produced for inspection before him, and comma, and if he is satisfied that there has been contravention of the order, may order confiscation of hyphen dot 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 dot, full stop. Section 6 capital B, next পড়ে করুন, has enumerated the provisions for issuance of show cause notice before confiscation of essential commodities. It has been enumerated that before the order of confiscation, the collector shall issue notice upon the owner of the vehicle stroke conveyance and the owner of such essential commodities. Full stop. Section 6B has also provided the opportunity of hearing and representations. Section 6B has also enumerated the power, the provisions for making order of confiscation. Full stop. Section 6C is a section capital C. Section 6 capital C. Section 6C of the Essential Commodities Act is an provisions of appeal against the order passed under section 6 capital A stroke 6 capital B, full stop. No, 6 capital A kor B na chhado hoche for accurate appreciation of the provisions, it has to be the section 6C is set out as follows. Section 6C টা তুলবেন না পুরোটা হয়েছে। Section 6C has enumerated that state government concerned shall appoint a judicial authority to hear out the appeal against an order of confiscation under 6A, 6 capital A of the Act, full stop. It is no doubt that the judicial authority, judicial term inverted comma দিয়ে রাখুন, mentioned in section 6C of the Act indicate a judicial officer, full stop. So it is duty bound for the state to place the it is duty bound for a person aggrieved against an order under section 6 capital A to place appeal before a judicial officer so designated by the state authority, full stop. It appears that the judicial authority, it appears in the impugn order that the additional district and session judge, being the judicial authority, has passed the impugn order. Full stop. Let me consider whether the impugn order passed by the judicial authority, within bracket, additional district and session judge concern, is a judicial order or is an order is a judicial order or is an order passed in administrative capacity, administrative stroke quasi judicial capacity. Full stop. In Radhesham Supra, the issue before the Honorable Apex Court was an interim order passed by a civil court in a pending suit. Wherein the Honorable Apex Court has decided that the decision of earlier decision of the Supreme Court in Surya Devi Rai is not a good law. Judicial orders of civil court are not amenable to writ jurisdiction under Article 226 of Constitution of India, but Article 227 may apply. Full stop. In Indrani Chakraborty, an order passed by a Chief Judicial Magistrate concerned in a criminal or in a criminal proceeding regarding order of further investigation by a police officer is under challenge, wherein a coronate bench of this court, after deciding all the issues, has held that writ under Article 226 of Constitution of India is not maintainable. Rather, Article 227 or 227 of Constitution of India or Section 482 of CRPC may apply. Full stop. In Kiran Devi, an order passed by the Waqf Tribunal under Section 83 within bracket 1 and 85 capital A of the Waqf Act 1995 is under challenge, wherein the Honorable 5 Judges Bench, after this is
3 judges, 3J.
3 Judges Bench. 3 Judges Bench.
Relying on 5 Judges Bench in L. Chandra Kumar.
3 Judges Bench has dealt with the observation of this court in Radhesham and is of view that whatever may be the nomenclature of the petition, either Article 226 or Article 227 of the Constitution, the jurisdiction of High Court to examine the correctness, legality and propriety of determination of any dispute by the tribunal is reserved with the High Court. Basically, the issue raised before this court regarding the maintainability of the writ petition, not clearly guided by any of the principle laid down by the Honorable Apex Courts. Full stop. In Essential Commodities Act for violation or contravention of an order under section 3 of the said act, there are two simultaneous proceedings. One is a criminal proceeding, that is penal action under section 7(1) within bracket A within bracket Roman 2 of the act, which provided for criminal prosecutions before a criminal court of law. The section 7(1) within bracket A within bracket Roman 2 denoted the term court, COURT, কোর্টটা করবেন হয়েছে, which also enumerate the provisions for convictions. Full stop. Simultaneously, section 6 capital A provides a provisions for confiscation. Admittedly, the power of confiscation and provisions thereof is vested upon the collector of the district, under whose jurisdiction the seizure has been made. Seizure of essential commodities has been made. After hearing the parties, the collector has authority to pass an order under section 6A for confiscation. Section 6 capital C is a provision for appeal, wherein it has been specifically enumerated that a judicial authority is the person to hear out the appeal. Full stop. The judicial authority hearing an appeal of an order passed by a collector under administrative function. Mere a judicial authority is empowered to hear an order, hear an appeal passed by the collector in an administrative order, does not ipso facto change the entire chord or essence, chord or essence of the proceeding into a judicial proceeding. Full stop. I can understand the submission of the learned counsel for the state that if a judicial order is passed by a judicial authority, that can only be amenable under section 227 of the Constitution of India. But in this case, only functioning of a judicial authority in holding an appellate power of an order passed in administrative capacity does not ipso facto convert the entire proceeding into a judicial proceeding. The statute specially empowered a judicial authority to pass an order in appeal against an order of collector means and includes it's an order passed in administrative side, not by an judicial side. I make it clear that the nomenclature of the proceeding being a criminal appeal is also not correct. The proceeding should be made as misappeal as per provisions of civil rules and orders. Full stop. As per provisions of Rule 776 of 776, Rule 776 of Civil Rules and Orders. 776 of 7 Rules and Orders. Full stop. Considering the entire submissions and considering the provisions thereof, in my opinion, the order passed by the impugn order passed by the learned additional district and session judge first court Basirat is not a judicial order but an order in administrative side. Thus, it is amenable to the writ jurisdiction under Article 226 of Constitution of India. Thus, the point of maintainability as raised by the learned counsel appearing on behalf of the state authority is not at all justified. Let the matter be proceeded. No, the matters are otherwise ready for hearing. Let the matter be fixed for hearing.
Let it appear tomorrow, my lord.
Tomorrow is not possible. Certain other matters are there.
আমরা তো 12-0 বলে হারছি দেবুদার কাছে। তোমরা যবে খুশি বলবে সেদিনকে করে দাও, 13-0 হবে।
21st of May at 12:30.
What is going to expect more?
Today. Till today.
21st of
6.
21st কি আছে 21 12:30.
The interim order to continue.
Interim order is there.
Yes, my lord. The first matter.
Okay. Interim order passed by this court be further extended till the adjourned date.
In this matter, there was no interim order. Only one interim order was lordship was inclined to pass, that is in item number 1. এটা কি একটা ইয়েতে ছিল?
সব একটাই order. And initially passed in item number 2, it was given
Whatever may be what was passed, that would be
same order.
No, my lord, only one thing, your lordship kindly pass a separate order to the text.
separate order in all the matters.
What
How many writ petitions are there?
There are 2 to 13, my lord.
Then you have to give me the names.
I will give the name.
You give me the learned counsel name of the you also give me the you also give me the names.
I have in one matter only. My lord. Number 2.
No, if it is a combined order, then the difficulty is that, my lord, the other juniors will be deprived.
I understand. I understand. Till the adjourned date. Till the adjourned date. হ্যাঁ আপনি ওই নামগুলো সব নিয়ে নিন। হ্যাঁ সবার নামগুলো একটা নাম নিলে হবে না, প্রত্যেকটা সবার নাম। ওকে ওকে ওকে
একটু নামগুলো দিন।
হুম সব পরপর থেকে দিয়ে যেতে ডাকুন, তিনটা ডাকুন।
CPM matter.
CPM matter.
CPM matter. Item 17. 21. Yes, sir. I'm sorry. Yes, I'm for the.
Serious 3 p.m.
3 p.m.
Other matters.
My lord, 2 p.m. matters are there, my lord. There will not be.
How can I deal with all the matters?
That's right, my lord. That's a,
Let it appear tomorrow
Well,
on the
only-
same heading.
only one, my lord, request if you are my lord. In 2 p.m. matters, second matter is mine, my lord.
Item number 14 and 15.
Item
14.
Najia Begum, my lord.
Yes.
My lord, it will take, it is the judgment already done by your lordship, my lord. In the similar case, in the similar name, everything. Can it be taken up tomorrow at 10:30? It will take only 5 minutes.
Not 10:30, come on 2 p.m. Let it be there.
2 p.m. my lord, there is already one matter above. And if your lordship continue, my lord, it will take 5 minutes only. Your lordship has given the judgment that will pass in this matter also. The same parties.
কালকে কি আছে? First matter would be It would appear first matter. Tomorrow. Yes, 10:30. First matter. it will appear. According to the diary, it will appear first. And
first matter.
And other matters will come thereafter. Okay. I have to take the 3 p.m. matter first. Yes, 3 p.m. matter. Omkesh Pal.
Mine.
Yes.
My lord, so far as kota number item আছে?
Read.
My lord, so far as item 17 is concerned, my lord, writ petitioner and the IOC is here. My lord, let it be taken up after vacation, man.
He is the petitioner.
I am for the petitioner, my lord. Already I have completed my
Yes, you have completed your argument. Well, then
learned friend seeks for adjournment. My lord, kindly make this matter part.
Parted, yes. Yes, yes.
Then I fixed any day, my lord.
It is already parted.
it is already made parted.
No, it is not part of it.
Not made parted.
Not made
It
part
will
of
be
it.
parted today, my lord. Only make this consent of all the parties, my lord.
Mr. Jadhav has to argue in this matter.
No. He will have to argue and then I will have to argue.
That is the land and otherwise the issue is that.
It was that he was in the first position.
Now the submission would be on behalf of the respondent, whether ordered to rule 2 is a constructive resolution.
Right.
That is only.
Right. Only that is the point. So come on tomorrow then. Why? What is the dispute? Mr. Agarwal, can you? Mr. Jadhav has concluded, not concluded. No, Mr. Jadhav has take the time. What do you want next week? After vacation, you want? Very well. Let the matter. Item number
17.
17. Let the matter. No, matter hard in part. Let the matter appear in the list.
2 weeks after vacation, my lord, because I will be out of station, my lord.
2 weeks after vacation. Very well.
Out of India, man. Out of India, man. Pakistan কি যাচ্ছেন না
পাকিস্তানের বন্ধুর কাছে আপনি
Yes, Mr. Sen.
My lord. Now, my lord, the short points, my lord, that are involved in this matter, lordship, kindly consider one thing. That my learned friend on behalf of the writ petitioner and the petitioner in contempt proceeding, well, the first point raised with regard to that, my lord, that maintainability of my application for recalling of your lordship's order.
Yes.
My lord knows that in the, my lord, normally, my lord, in our, my lord, in a high court, my lord, whenever an application is made, my lord, it is not necessary, lordship knows that very well by this time, it is not necessary to mention the source of the application and or the sections which I resorted to while filing the application.
Yes.
Not necessary. But still, my lord, this application which we have taken up, the application which has been taken out, that application, my lord, are marked as, my lord, application under Order 9, Rule 13 under Civil Procedure Code. Now, the question came up and the issue raised first with regard to the maintainability of that application, and my learned friend said on the last occasion that the Civil Procedure Code is not applicable in writ jurisdiction.
Yes.
Citing a Supreme Court judgment. And also,
141 of this. Section 140.
unless, my lord, he takes his seat, my lord, it will be very
Yes,
difficult.
you have argued. I have taken note of.
My lord,
Section 141 of CPC.
yes.
You have argued.
Yes. Now, my lord, my learned friend said that in view of that provisions under Section 141 of CPC and the Supreme Court judgment, my learned friend
Here
denied.
today.
So, the application is not up to the portion, so the application is not maintainable. So, my first answer would be that my application is maintainable.
Yes.
In its present form. Now, my first answer to that is, lordship, kindly have a look on the কি ঘাটলো বলো তো সব সাজিয়ে রেখেছিলাম
কপি টপি গুলো সব কি ঘাটলো আমি তো ভেবেই পাই না।
Yes, Alom, your matter is there. Next matter.
Yes.
That is Bose Institute matter, just wait. Is it possible today, Bose? As because I was not there, all come under the, yes. I will take up the matter on Wednesday. As it is, I am taking. Yes. Wednesday. Bose Institute cover রাখি Wednesday তে রাখি তো first half এ Bose Institute Wednesday second. Wednesday second half it will appear
for Milord's country because we are going to your court judgment.
Yes, only some few matters are there. Either Wednesday 10th at 12:30 you can do the matter.
Wednesday 12:30.
Just long pending matters are going on. I am hearing these matters since 3 months, I think.
3 months.
3 months. Only 2 writ petitions complete, or another 2 is required to be dealt with. This issue is going on very long issues. Wednesday?
আছে দেখতে হবে তো।
কবে 12:30 তে আছে 12:30 Wednesday 12:30 12:30 Wednesday মানে বলে দাও 15 তারিখ হবে তো কবে 6-7 তারিখ হবে তো 7th 12:30 এই সবগুলো মার্ক করে দাও 7th 12.
Yes. Now, my lord, kindly have a look. Lord, this is the, my lord, the Xerox copy of the, my lord, our rules of the High Court in Article 226 matter. My lord, this is a Xerox copy. Lord, kindly have a look. My lord, the paragraph number is clause number or section 53.
Yes.
53. 7 except as provided by these rules and subject thereto the procedure provided in the Code of Civil Procedure in regard to suits shall be followed as far as it can be made applicable in all proceedings for issue of a writ.
Yes.
So my first answer against this, that not maintainable, my first answer would be that when the Civil Procedure Code has been adopted by the Honorable High Court, Calcutta, for the purpose of, my lord, disposal of writ jurisdiction, whenever it becomes necessary, my lord, to take help of any of the provision, then, my lord, it is, my lord, very much, my lord, applicable, and in my case also applicable. I can take resort of that, number one, because the rule permit this, our rules of procedure. Now, my lord, there is a judgment, a very old judgment, and that I rely upon. That is, my lord, AIR 1996 Supreme Court 1092. এটাও দেবেন। AIR 1996 Supreme Court 1092. My lord, before my lord going through the paragraphs, I do not want to, my lord, invite your lordship all the paragraphs. Fact of that case was that when the matter went up to the Supreme Court, the Supreme Court says that various high courts, they are in a limbo with regard to that issue, that whether while they are proceeded with in a writ jurisdiction, whether Civil Procedure Code can be followed. If followed, then there are certain disadvantage of the Civil Procedure Code with regard to the somebody can delay the proceedings. And at the same time, the advantage is that there are certain situations may arise. Suppose substitution and other thing. Then what would be? Then it was a case where it appears that timely the steps were not taken to substitute the parties to the proceeding.
Amendment is there.
Amendment. Matter went up to the Supreme Court. Now, lordship, kindly come to paragraph 8, almost towards last sentences, paragraph 8 at page 1097.
Yes.
Because what I said before your lordship, that was the facts set out herein. Now, in the case of such and such reported in year 1984 Karnataka, in view of Rule 39 of the writ proceeding rules as framed by
you are
the
reading paragraph 8.
Paragraph 8, last sentence at page 1097.
Okay.
Lordship, kindly directly come to that last sentence of that paragraph 8. It starts in the case of.
Yes.
In the case of such and such, reported in year 1984, Karnataka 234, in view of Rule 39 of the writ proceeding rules as framed by the Karnataka High Court, making the provisions of the Code of Civil Procedure applicable to writ proceedings and writ appeals, it was held that the provisions of the code were applicable to the writ proceedings and writ appeals. Then 9. We have not been able to appreciate the anxiety on the part of the different courts in judgments referred to above, because judgments referred both the side before the Supreme Court. In judgment referred to above, to apply the provisions of the Civil Procedure Code to writ proceedings on the basis of section 141 of the code.
Yes.
Now the important, Lordship, whether the writ court's power is limited or not. When the Constitution has vested extraordinary power in the High Court under Article 226 and 227 to issue any order, writ or direction, and the power of superintendence over all courts and tribunals throughout the territories in relation to which such High Court is exercising jurisdiction, the procedure for exercising such power and jurisdiction have to be traced and found in Article 226 and 227 itself. No useful purpose will be served by limiting the power of the High Court by procedural provisions prescribed in the code. Of course, on many questions, the provisions and procedures prescribed under the code can be taken up as guide while exercising the power for granting relief to the persons who have invoked the jurisdiction of the High Court. It need not be impressed that different provisions and procedures under the code are based on well-recognized principles for exercise of discretionary power, and they are reasonable and rational. But at the same time, it cannot be disputed that many procedures prescribed in the said code are responsible for delaying the delivery of justice and causing delay in securing the remedy available to a person who pursues such remedies. Now the important again, the High Court should be left to adopt its own procedure for granting relief to the persons concerned. The High Court is expected to adopt a procedure which can be held to be not only reasonable but also expeditious. Now, Madam, in our High Court, this rule has been, my lord, adopted. This is the procedure, just like in Karnataka High Court. Now, even in absence of the rule, the Supreme Court says that High Court in its writ jurisdiction, its power is not limited to the code. It has its extraordinary power and derived from Article 226 and 227. So, my lord, my humble submission is this, that this application taken out before your lordship for recalling of your lordship's order which was passed ex parte because none appears on behalf of the respondent, my lord, that is, my lord, if the reason has been explained, and if my lord is satisfied on the basis of the reason, explanation that why none appears, then my lord, I think, my lord, that the application that would be, my lord, allowed, but not that it is not maintainable. The court is powerless. Once the order passed, there is no such remedy because the Civil Procedure Code 141 is not applicable. As per section 141, CPC is not applicable.
Okay.
Now, my lord, since my lord, is taken up the matter also on the basis of the, my lord, the points which I have taken in my lord, the affidavit. Though, my lord, I on the last occasion said that it could not be, my lord, filed because none appears on that day, but it was affirmed, my lord, long back, and the copy already annexed to my application. কোথায় গেল? অরিজিনালটা কোথায় গেল? ছিল তো এখানে। Now, my lord, I have told before you that, my lord, it was affirmed, the original affidavit, in terms of the order passed by this court on the first occasion when the matter was taken up. Now, my lord, it was affirmed on behalf of the respondent State Transport Authority, that is the CSTC. My lord, it was affirmed on 15 December 2020. And, my lord, since thereafter, my lord, the matter first appeared before your lordship and none appeared, my lord, the original is with us. The advocate, naturally, my lord, we could not file. But, my lord, a copy of the affidavit, my lord, that has been annexed, my lord, to my application. Can one. Now, my lord's notice was drawn to the, my lord, the stand taken in the affidavit. And, my lord, by mistake, my lord, the affidavit, the copy of the affidavit was subbed on, my lord, 8 February 2021 upon Mr. Sushmita De Basu, who normally, my lord, in most of the matter against CSTC, who appears in service matter on behalf of the petitioner. And, my lord, it was subbed upon him, and, my lord, he accepted that notice. Now it appears that, very good, my lord, that my learned friend is appearing.
Yes.
Now, my lord, if your lordship, my lord, kindly, my lord, just, my lord, once more, if your lordship, kindly have a look, my lord, that particular, my lord, copy of the
Now,
affidavit.
what is your ground of recall? The order has to be passed in Can 1. What is your ground for recall?
The merit.
Merit.
Yes. Now, my lord, kindly, my lord, yes, I'm very, my lord, grateful to your lordship. Kindly have a look at paragraph number 5. Of the annexure to Can 1, that is the said affidavit.
Yes.
Paragraph 5, let's have a look at it. Paragraph 5. With reference to the statements made in paragraph 4 of the said petition, quoting clause number Roman 12 of the letter of such contractual engagement, I state that, first of all, the scope of the provisions for regularization subject to several terms and conditions mentioned in the said GO number 1700 EMP dated 3rd August 79 issued by the Labor Department of the Government of West Bengal was restricted to the contractual or casual workers who had already been engaged under the state government. My lord, kindly, my lord, take note of it that 79, 3rd August 79, that circular that has been annexed to the writ petition also, that 3rd August 79 circular issued by the Labor Department. And, my lord, the writ petitioners, my lord, the main, my lord, their foundation of their case was that because of that Labor Department notification And in view of the mentioning of that notification in his engagement letter, while contractual engagement was made, so his engagement should be regularized on that basis. Now, my lord, our stand is, if your lordship kindly have a look, that particular 79 was restricted to the contractual or casual workers who had already been engaged. This was the line, my lord, in the circular. Not that after that who will be engaged under the state government. And second, under the state government. And the same is not applicable to the petitioner whose engagement in the corporation was made by issuance of a letter of engagement being dated 16th of December 2002. After that GO, because the scope of the GO cannot be enlarged in that way by anybody. And that too not under the state government. Petitioner's engagement was not under the state government. Calcutta State Transport Corporation is an undertaking, but my lord, the service regulation and everything, appointment, procedure, everything different.
Why the appointment letter demonstrated the GO?
My lord,
GO of state government.
I do not know, my lord, but my lord, I am coming to that also.
Okay.
That too, see, that too not under the state government, is none of the employee of the respondent corporation, whether casual, contractual or permanent, enjoys the status of the state government employee. Then apart from the scope and doctrine expressed by the said circular GO number such and such of 3rd August 79, it has also lost its force in view of several subsequent GO or circulars issued by the Labour Department covering the said field. And further, whatever scope of regularization or casual contractual workers was floated by the said circular, the same has been negated by the catena of judgments delivered time to time by the Honorable Supreme Court. But that is regarding my lord, regularization. Regularization, my lord, there are several judgments that when the regularization can be ordered passed. Now, my lord, kindly my lord, one thing lordship kindly consider.
Yes.
That page number 28 of the writ petition, where that engagement, letter of engagement annexed with that, my lord, particular mentioning of that circular or GO.
Yes.
My lord, Roman 12, page 28. Have you also got in, my lord, in the writ petition? Question of absorption in regular establishment would be considered as per provisions made under GO number 1700 dated 3rd August 79, read with circular number such and such, and on completion of 720 days satisfactory duty from the date of engagement as daily rated trainee worker according to the availability of vacancy. Now, it was nobody's case that vacancy was available. In any event, my lord, the straightway they said that because of this circular. Now, my lord, to that extent, my lord, our submission is this, that if it is not at all applicable, if you lordship kindly come to once more, my lord, that circular, once more. That circular, my learned friend annexed it at page 35, a type copy. Annexure P5. May I read, lordship, again, my lord, that circular, the first Labour Department circular subject. Subject denotes everything, lordship, the contents and applicability. Principles to be followed in the matter of absorption of casual and such other categories of workers under the state government. It is stated therein, under the state government. Then followed by in this way the contents. Government of West Bengal have for some time past been considering the question of discontinuation of employment of casual and such other categories of workers in perennial type of work, and the question of gradual absorption of all such categories of workers employed from time to time by the employing authorities under the state government
Yes.
So whatever the benefits percolates after this and on the basis of this circular or geo, my lord, those benefits are, my lord, restricted only those persons who are engaged as a casual employees under the state government.
Yes.
But not undertaking. CSTC is an undertaking. Now, then, my lord, kindly have a look the next para. Further recruitment of casual and such other categories of workers shall not be normally made. Initial recruitment of such workers, if considered unavoidable by any employing authority, shall henceforth be invariably made through the employment exchange. It is nobody's case that his engagement was through employment exchange. As already decided in the case of filling up vacancies, non-PSC, non-promotional.
Tomorrow?
Tomorrow.
Tomorrow first matter?
Tomorrow?
First matter.
Morning.
Morning.
12 p.m. 12 p.m.
12.
You kindly.
Or after recess, if your lordship.
After recess, I have fixed some matters. Already 2 p.m. matters.
Take last time. He said I will take only 10 minutes.
Who says this?
After him.
I
I don't know how many times he will take. I will take 10 minutes only. Now there are some judgment.
কালকে
দাদা এটা একটু ঠিক আগে ওনাকে দেখেছি কমপ্লিট করতে না
12:30 কিছু আছে
12:30
12:30
12:30
12:30
12:30
okay tomorrow 12:30
tomorrow 12:30 Malar kindly take
yes I'll pass the order.
So kindly remember that 12:30 it will finish.
12:30 I have take up the matter.
Yes, yes.
Either I have busy other matter that will be
I will get to your
consequential.
lordship that your lordship can please.
Very nice.
My total item number is 50.
Just wait.
দাঁড়ান অর্ডারটা লিখছে সময় দিতে সাথে
Argument on behalf of the authority concerned, on behalf of Mr. Sen is hard in part. Let the matter fixed tomorrow at 12:30. Another same heading.
I'm grateful to you.
Yes. Yes, your matter?
Item number 50. This matter.
1-5.
1-5. Yes, ma'am.
It will appear tomorrow. It will appear tomorrow. First, second matter.
Second matter.